Yes.
Okay, back to mention item number 13, Lordship, with the consent from the other side, Lordship. In this case, Lordship, respondent has filed their affidavit on the day before, Lordship, on 28th. I'm waiting for some time to take instruction from my client.
Okay, Mr.
Ash Chakraborty.
S. Chakravarti, let us pass it for the petitioner submit step. Affidavit and position has been filed by the respondent number,
Provident Fund, Lordship.
huh?
Provident Fund, Lordship, 1 and 2.
By the response number 1 and 2,
Yes, Lord.
only 2 days back,
On 20th of April.
on 28 April. He accordingly prays for time to go through the same. Praise allowed, this is the matter after
2 weeks,
2
Lord.
weeks.
No, with the consent of the petitioner, I beg to mention item number 11 and 12. It's a partner matter, my lord, but I need to take it, the instruction there, and the instruction has not come, my lord. So let it be on 15th, my lord, until 7.
Okay, right. Mr. S. Bora
SCERT.
appearing for the
SCERT.
SCEI submits that. Appraise that the matter may be adjourned and submits that is taken the consent of the other side. The partner matter.
Partner matter, there's one specific concern, whether the post is there, whether he could be accommodated or not. That since there is a lot of holidays between.
And the same is not objected to by the petitioner's counsel. This is the matter.
On 15th.
Okay.
That's partner. It's a partner matter.
It's a partner or matter.
May it please your lordship. Lord, I beg to mention a matter for listing, my lord, for litigation. Lord, on Monday, my lord, there's an urgency relates to a shifting of a liquor shop, my lord, and highly applied.
May I please your lordship, with the consent of the other party, I beg to mention item number 8, your lordship. Lordship, the conducting counsel for PTC, Mr. B. Chaudhary, is unavailable today due to personal difficulty, your lordship. So pray that matter may be adjourned today.
Yeah, any objection? No. Ms. R. M. Barwa, prays for adjournment of the case on behalf of Mr.
B. Chaudhary, your lordship.
B. Chaudhary, Learned Counsel for the
BTC.
BTC. The same not being objected by the petitioner's counsel. This is the matter after
2 weeks, your
2
lordship.
weeks. You were it.
Well, may I pray for passing over the matter for the timing? I'm led by Mr. Kane Chaudhary. After something. There is urgency in the metro, my lord. For the timing, my lord.
So your case is that the respondent number 7, whose bid is higher, has been settled with the market.
No, my lord. Rationale number 7 was the 7th highest bidder, but it has been settled on the ground that the others, my lord, the petitioner and others, they bidded over 10% of the bid value.
Over the 10%. And
And
that
my-
is based on a cabinet decision.
My lord, my case is that, my lord, firstly, in the NIT, there was no such condition imposed. Secondly, my lord, the cabinet decision they are relying on, that is with respect to Panchayat department, not my lord, the municipal administration department. And secondly, my lord, they say, my lord, there a pre-bid meeting was held. And my lord, there it was discussed that that's this
Okay, so the first point is that based on a cabinet decision
of Panchayat department,
regarding Panchayat department.
my lord.
And the present case pertains to which department?
Municipal administration department.
Municipal
Municipal administration department.
administration department. And second point?
In fact, my lord, the first point is that, my lord, in the NIT, there was no condition that, my lord, no one can be higher than the 10%, my lord.
In the NIT, no
condition.
condition. That bidder cannot bid higher than 10% above,
Above the,
above 10%.
above 10%.
Higher than 10% of the estimated amount.
No, my lord, not estimated value, this is the average value of the last 3 years.
Of the average value. Average value
Of the last 3 years.
of the last 3 years. And what is the third point?
Third point is that, my lord, even my lord, in the, after the cabinet meeting, even the Panchayat department said that, my lord, these clauses have to be incorporated in the NIT. And my lord, that clause was not incorporated in our NIT, that 10%.
Panchayat department is.
My,
But so anyway, so this 1 and 3 the same.
about my lord, only an extension of that submission.
That the because
Firstly,
your case pertains to the municipal administration department. So whatever decision Panchayat department takes does not affect you.
Does not affect me, even my lord, subsequent to that also, the Panchayat department itself said that, my lord, the condition has to be incorporated in the NIT, that is the subsequent, my lord, notice they issued pursuant to that cabinet decision. Then, my lord, they said that there was a pre-bid meeting, and in the pre-bid meeting, it was decided that, my lord, that 10%, my lord, of the, my lord, viability range, that was decided in a pre-bid meeting,
Decided that no bid should be higher than.
10%. Now, my lord, that we are challenging on two grounds. One is first.
So you were not part of the pre-bid
So
meeting.
firstly, my lord, in the, there was a pre-bid meeting. but
You-
in-
you
in
were
the
part of-
NIT, my lord, there was no condition of the pre-bid meeting.
Correct.
Yes,
My question is, were you present in the pre-bid
I was
meeting?
present in the pre-bid
And
meeting.
you were aware of the decision?
No, my lord, that decision was never discussed, my lord. The pre-bid meeting was with respect to extension of 1 day of the last date of submission. And they have, my lord, not produced any minor meeting. And in fact, my lord, they have admitted.
That will be incorporated in the.
The executive officer has admitted, my lord, there is no minutes of the meeting. That is on record.
So that is your case.
Yes, fine. And my lord, the case of the private respondent is that we have suppressed the fact that there was a pre-bid meeting. Against that, my submission is that, my lord, it is a, my lord, non-disclosure of a non-essential fact. That was
This
the
was what?
point.
This was what?
Non-disclosure of a non-essential fact. Because, my lord, the viability range was never discussed in the pre-bid meeting, therefore, it was only limited to extension of 1 day of the last date of submission of the contract. This is literally the case, my lord.
Anyway, let's Mr. Casey come.
My lord, I'll wait, man. And, my lord, there is a note early order, your lordship must have seen, my lord, that this has come up for final disposal today. In the meantime, settlement has been given to the private respondent, and, my lord, the possession has also been taken over by the private respondent. That's why, my lord,
What is the amount?
the bid amount is, my lord,
Official bid amount was 73 lakhs.
That is the reserve price.
that was, reserve price was 73 lakhs.
So reserve price was 73 lakhs. That's all.
And, my lord,
73 lakhs 60,000.
60,000.
Sorry, I'll give the exact figure.
exact, my lord, figure.
73 lakhs 60,000.
The
And respondent number 7.
80 lakhs 93,911.
How much?
809391.
8093
911.
911.
and the petitioners be
Petitioner,
1,23,00,000, 1235300
my work. So that means to make up this amount, probably you'll have to charge higher.
No, my lord, I cannot. That is the condition, my lord. I'll draw your lordship's attention to the NIT. It says, my lord, the total will be collected as per their, my lord, the figure they gave, man. That is a clear direction.
As per the,
My lord, AC must collect tolls at the rates fixed by the Dhing municipal board.
so is the rate fixed?
Rate is fixed, my lord. That is there in the tender condition.
Which clause is that?
That is clause 9 of the NIT. This clause was my lord, already considered, came up for consideration before this honorable court. I have annexed the judgment also, some other judgments if required, my lord, including the SFH and some division bench judgment of our honor. So we'll wait, my lord.
Let us,
I appear for it's not my municipal court. After Mr. Chaudhary completes the
okay. We issue notice. Notice issued.
This fix for instructions, my lord.
Yes, first.
Please, my lord. My lord, till now we have not received any instruction.
Okay, right. Your name is?
And get asked.
Right, Mr. M.K. Das, for the petition, who submits that pending bills of the petitioner amounting to rupees 4,85,000 have not been paid. Issue notice returnable in 4 weeks. Mr.
K. Vishwakarma.
Huh?
K. Vishwakarma on behalf
K.
of Mr.
Vishwa-
S. P. Chaudhary.
Sir,
Vishwakarma, my lord.
Vishwakarma,
Yes, sir.
appearing on behalf of Mr.
SP Chaudhary for respondent, all the respondents.
S.P. Chaudhary, accept notice on behalf of all the respondents. This is the matter after 4 weeks to enable the response to file their affidavit.
Yes. Extra copy maybe, sir.
Please. Extra.
May I please your lordship? Lordship, senior advocate Peter Sokia is another report kindly meet our passover for time being.
Why?
Is another
Who? No, don't look back. I believe you, but who's the lawyer?
sir.
Huh?
Senior advocate PJ Sokia, sir.
Yes, what to do?
Kind-
He's asking for time.
We'll wait. I have the matter at court. I will also get
Yes. After some.
Like,
Regarding that blacklisting matter yesterday, the lawsuit was taken. Only a few points I would like to show to your lordships. I understand what was the query from your lordship on the last occasion.
His basic case is that
Uh,
till a decision is taken
Yes.
with regard to the blacklisting of his company, how can you straight away give effect? No, you suspend his participation and reject his bids when the decision has not been taken with regard to blacklisting.
Suspension part of that show cause, I leave it to your lordship.
That is what he's saying.
Regarding the second part of that blacklisting
Decision has not been taken.
blacklisting decision,
Has not been taken.
I would request your lordship to provide us the opportunity to exercise our rights.
No, that you got. I don't have to give any
Yes.
permission to you.
Yes,
That
sir.
you have got. Only thing is that till a decision is taken with regard to the blacklisting, he cannot be debarred from participating in any other tender except for the present tender. He cannot be debarred. Or the termination of the contract, the present contract,
Yes.
cannot be a ground for debarring him from participating in other contracts or rejecting his tender bids.
Blacklisting would entail a rejection.
Blacklisting will
So
entail,
therefore,
but
in
you're,
this-
you're giving the effect of blacklisting prior to a decision being taken by
Yes,
you on
because
that.
the difficulty is, if during the period this tenders are processed, the blacklisting order comes, that creates a difficult situation because they're in a situation where the person is
What
blacklisted,
to do?
but I need to proceed to give the contracts to him because probably he has been found to be more suitable. So
You
therefore,
see, there is a very simple thing. to
therefore, what the
that.
authority
You see,
does
one
is-
thing is that you can defer the taking a final decision on those contracts.
that
That
will
is
not
one.
know whether he will succeed or not.
That is
So
why.
that's what I'm
So
saying.
that is why. Or you can, if you're in a hurry, tomorrow you can take a decision.
What? So therefore, my submission
Otherwise-
should be suspension. I leave it to your lordships, and blacklisting we will be allowed to proceed. Lordship. And notice may be issued
That-
in this matter. We'll file it.
What notice is required? That's the end of the matter.
If he doesn't challenge this, the show cause thereafter.
Correct.
Well,
No, how can he challenge a show cause? He cannot
because
challenge it. There's
his
no,
case.
no, he cannot challenge a show
Yes,
cause.
then.
The entire case is basically that till a decision is taken on the show cause, you cannot give the effect of the result that might be passed
Well,
on the basis of the show.
yes, your lordship.
That's the only issue.
Yes. Lordship will not put it on my mouth. I leave it to your lordship on the suspension part.
Only that. That is the only
Yes.
issue to be decided.
Yes.
Nothing else to be decided.
And blacklisting will be allowed to proceed.
You blacklist
the
him,
exercise.
you blacklist him 10 minutes later also. How does it matter?
For 20 minutes, he will come with a new petition.
He will, that is right. That is right. Everybody has got a right.
I understand.
Uh,
Yes, your lordship.
I think then the writ petition is this.
That means
So whatever action has been taken by you on the basis of the termination
yes.
in respect of other cases, that will have to go.
Yeah.
Because he had participated in some other tender. But because of his termination here and the show cause notice that has been issued to him for blacklisting, his bid has been rejected. So those will have to go.
Yes.
Till a decision is taken for blacklisting, that suspension portion of him not being able to participate.
Actions taken by Oil India post the so-called notice.
Post the show cause notice,
That, yes.
post the show cause notice, and on the basis of the termination of his contract in this case.
That instruction I do not have as to what,
On the basis of the suspension.
because what I understand is.
Okay, on the basis of the suspension, we'll
Suspension.
just say on the basis.
Because there are two NITs that are presently
Yes.
in considerations, only regarding those issues, not something beyond that.
Right.
For that, I have to take
Right.
instructions on that.
Yes.
Okay, right. I think the last order we have made, this right, heard Mr. G. N. Sayawala, Learned Senior Counsel, assisted by Mr. M. Sayawala, Learned Counsel for the petition. Also heard Mr.
Yes, sir.
A. Sharma,
Standing
Learned
counsel
Counsel,
on the-
Standing Counsel for the Oil India. Limited. Then the last order, you just say the petitioner's case is that the petitioner was awarded the contract of continue. Okay. And para 2 also you take, para 3 also, para 4 also. This yesterday's order will do, I think.
My lord.
Then para 5, right? The petitioner's counsel submit that till a decision is taken by the respondents to blacklist the petitioner, to blacklist to put the petitioner on the holiday list. The same
Same thing.
holiday list / blacklisting.
Holiday sounds better.
But this is unpaid holiday. Pursuant to the show cause notice dated 24/4/2025. The effect of the suspension order as provided in the show cause notice dated 24/4/2025 would have to be set aside as the same. In effect, puts the petitioner in the holiday list immediately, prior to a decision being taken on the show cause notice dated 24/4/2020. Okay, then what Mr. Kalida submission, I do not know whether. Okay, so what do I write for your submission?
My submission would be that I may be allowed to go ahead because it
Okay,
is a case of termination.
Mr. A. Sharma, learned counsel for the oil submits
Clause 44.5 enables me the right.
that there has been a termination of the petitioner's contract in relation to rig
Number
John
16.
16, as the petitioner has not been able to procure the top drive for John 16 within time. That is till 1/7/2024. Then that is before 3:30 PM of 1/7/2024.
Before 31/5/2024. Why I'm saying so, my instructions is this email is not an email that is issued by the competent officer. Because
before
before
31/5/2024.
2024. As
In as much as the email dated
1st of July.
1/7/2024, providing that the top drive should be procured before 3:30 of 1/7/2024, has not been issued by the competent officer of oil. Yes, sir.
That is the contract department, chief general.
Anyway,
Yes,
I
I
mean-
think.
The petition, the Mr. A. Sharma submits that. As there was no infirmity with the issuance of the show cause notice dated 24/4/2025. The issue raised by the petitioner in this case should not bar oil from taking a decision on the show cause notice dated 24/4/2025.
Yes.
Have you filed a reply to the same?
No, we shall file, well, time is there.
Directly.
24/4/2025. And the reply to be filed by the petition. Which would be in terms of clause 4.15,
44.5
clause 44.5
of the general conditions of contract.
of the GCC.
Yes, so much.
Yes, sir. Next, I have heard the learned counsel for the party. The show cause notice dated 24/4/2025 clearly shows that, where is that page?
Well, they paid 174.
Starts at 170.
120.
Clearly shows that
Or party was 120. 176. 176.
the matter pertains to the inability of the petitioner to procure the top drive for rig John number 16 within the time period provided by the oil. And as such, the show cause notice has been issued due to termination of the petitioner's contract and to put him on the holiday list in terms of clause 44.5 of the
Yes, sir.
of the
44.5.
GCC. Yes, sir. However, interestingly, the show cause notice has placed the petitioner on suspension for a period of 3 months from the date of issuance of the show cause notice, which in effect bars the petitioner from participating in any other contracts under oil. Full stop. This court is of the view that the placing of the petitioner under suspension in terms of the show cause notice dated 24/4/2025 amounts to basically giving a decision on the issue to be decided by oil prior to a decision being actually made as to whether the petitioner should be put on the holiday list. Yes, sir. The same, no, full stop. The same in the view of this court is arbitrary and unreasonable. Yes, sir. In view of the reasons said above, this court is of the view that though there is no infirmity with the issuance of a show cause notice dated 24/4/2025 and no, which issue which issue would be decided, and the issue is would be decided on the basis of the reply made by the petitioner. The suspension of the petitioner during prior to the show cause notice being decided and being not sustainable has to be set aside. Accordingly, the show cause notice dated 24/4/25 is not being interfered with, except for the portion where it has held as follows. Page 176. Further, second last paragraph in red. Consequently, any action taken by the respondents pursuant to the show cause suspension, pursuant to the suspension of the petitioner for a period of 3 months, as provided in the show cause notice for suspension dated 24/4/2025 is hereby set aside. And Bangalore got locked in Bangalore, that will be.
Automatically, whatever consequences are there, it will happen. So only one observation. I think on the last occasion, lordship in those paragraphs have written that prima facie there is no termination letter or termination order, because your lordship has asked him to
I have said
that observation may not be there.
the email says a simple reading of the above prima facie shows that oil has not terminated the contract.
Probably that observation will be,
Subsequently, that can be clarified.
because what I'm saying is regarding this issue, that this letter has been issued.
Okay,
by the
that's fine.
competent,
It is also
not
made
by the
clear.
contract department.
It is also made clear that the observation made in para 7 of the order dated 30/04/2025, that is, inverted commas, a simple reading of the above prima facie shows that the oil has not terminated the contract involving John number 16. Inverted commas closed, will not influence, will not have
Any effect?
will not have any effect. No, should not be considered to be the final observation of this court.
Much. And the authorities can proceed to take a decision independently of the observation.
It is needless to add that the petitioners can,
No, the respondents,
the respondents can take a decision on the show cause notice
independent of that observation.
dated 24/4/2025, independent of the observation
Made by.
quoted above.
Obliging.
The writ petitions accordingly disposed of. Item
15. Lots of
15.
In this matter, I am paying
that let this matter come up.
15th?
One.
Okay.
Let this matter come up on Monday, Lordship.
Why?
because Copy has not been served.
The last date of submission is tomorrow, Lord.
Copy has not been
Finding
served to me, Lordship. Yesterday also I have informed my learned colleague, the senior counsel chamber, to kindly provide me the copy of the petition. Although they were supposed to submit today morning, but I have not received any copy, Lordship.
Your Lordship, can it be taken up after some time, Lordship? Senior counsel BD does his own legacy speak.
You have issued a fresh tender.
Lordship, I don't have the copy of the petition, Lordship. I'm not aware. Yesterday also I have.
Why haven't you given a copy?
Although
How
our
did they file?
Yes, Lordship, our name has been reflected. That's its strength, how it has been filed.
Some misunderstanding maybe, Lordship, I will clarify it and Lordship will pick it up after some time, Lordship. Meanwhile, it's up.
After some time, we won't pass any, there cannot be any stay order at the time.
Something.
Okay, Lordship.
I know.
That is a virtual. So this, I think, several now hearings, like I said, before court number two. and
What number?
Court number two.
Two.
And my lord, only for after we have completed the hearing. for a particular
Actually, Lordship, there were several hearings happened. The matter was concluded. Only 3 documents were sought from me.
So we'll place it before the.
Yes.
Okay, right. Ms. N. Saikya, learned counsel for the petitioner, as well as Mr. A. Kalita, learned counsel for the Industries and Commerce Department, submit that the hearing has been concluded before the court of the Honorable Mr. Justice L. S. Jamir. They submit that only 3 documents were to be provided to the court to enable the court to take a final decision on the matter. They accordingly pray that the matter be listed before the concerned way, appropriate way. In view of the submission made by the counsel for the parties, list the matter before the
six.
appropriate way. But there's not appropriate, we cannot say appropriate, before court number 2. Court number 2 on
Six.
Obliged.
My lord, this is matter with commenced hearing on Monday, where without any privity of contract,
Yes.
they have come up contract.
Lordship, final case may be examined for the timing, Mr. Kedas engaged in a matter.
Who?
Kedas.
Kedas. Okay, we'll wait for the time. All waiting. Once we start that other item, they won't have time.
Hello. There's a next one.
I cannot wait. I'll rise then. I'll rise from the court. You will. You see, I've tried to accommodate. Now the list is gone. Now the list is exhausted. Now what do you want me to do? Wait here while they are, huh? Yes. You should understand that I have already now got around 5, 6 matters here. I think 4 matters, 5 matters, which has been, now we are waiting for the councils. So we have tried to accommodate you. My list is now exhausted. The next case that is going to come up is a matter that is going to take the whole day. I have heard it for 3 days already. So if you all want, then if you are not in time, I'm going to adjourn it for 3 months. And I'll make sure that it is not even an adjournment slip will allow for it to be posted. Yes,
What we may take when item number 7, because this case is covering the item number
7.
6.
yes.
It is regarding the settlement of ferry service, madam. This is Gomaghat ferry service. But in response to the NIT, it is on 8 to 2024.
Just a minute. NIT dated
8 to 2024. Madam.
8 to 24
Yes, madam.
for a period of 2 years.
I did 2 years, for 2024 to 2026.
26, 2024, 2026. Okay.
And the NIT, they call for a total 23 numbers of the ghats, and among which, the Gomaghat ferry service at place serial number 12, Dorsey will come to the annexal 1 at page 43. Madam.
No, you see, your case is what? Your case is that you are the highest bidder.
I was the highest bidder. Madam.
Then it
Yeah,
has been given to
But
the respondent number 4.
Initially, in technical bit, that was competitive statement was made in 13.3, my lord, in which I was found that I was the highest bidder and I filed all the documents, completed all formalities. But the remark it is saying that they no up to date of the NIT. But on the basis of that,
No up to date?
NIT, NEC, my lord. Sorry,
NOC.
NEC. Not-
NEC or NOC?
non-income certificate. Well, it is so but with facts was that I have,
Non-encumbrance certificate.
but well, I have
Whole problem comes up, my lord. The valuation certificate who we had submitted, that was cancelled on the basis of a complaint made by a Patadar.
Okay.
Because valuation certificate is a essential document as per our law. So that valuation certificate was selling in the first place.
In the first case?
Yes.
Okay.
no,
And so in the first case, you value selling.
valuation came.
Valuation cancellation was selling in the first case.
No, in first case, valuation cancellation not challenged by law. In first case, by law, I challenged by my cancellation, my settlement. Because they continuing my settlement.
You challenge your own settlement.
Settlement, because I was allowed to run the settlement ferry service for consecutive pilot sum in 15 days basis till I was settled is June 2024. My lord.
Okay.
So he is confusing himself, my lord. In 4177, he has paid 4177, my lord.
Yeah,
He
another case
paid.
also there. Another case.
Then how the 2 cases pending ultimately
No,
boil down to that, my lord.
let me finish, my lord, then
Make sure.
let me.
4177, he has challenged that speaking order, my lord.
Earlier occasion, my lord, first writ petition, that was my lord 4300, that was disposed by.
Just a
Dorsey.
minute, just a minute.
Order is I have annexed, my lord.
That the third prayer, my lord, and so called as to what.
Just a minute. You sit down.
I'm here.
Okay, no, let us go systematically.
Yes.
You had filed the first writ petition.
4300, my lord. First,
First writ petition is,
that was disposed of, my lord, 4300.
where is the order disposing that?
Yes, I have annexed, my lord. This is annex 7, my lord, this is. Next, sir.
Huh? Which writ petition?
4177.
No, I am taking this, my lord, let's.
Yeah, so,
Dorsey, my lord, at page
Seventy-nine.
is 79, my lord.
79.
Of the second or first writ petition?
It is well as 7-1, my lord. This is 4349. 4349. That will cover all the cases, my lord.
77.
4349, that is
Page 79.
79. Yes, Lord, sir.
Yes.
So, my lord, when the, my lord, they,
No, let us read the order.
yes, my lord. It is very clear from this one.
Participated in the NIT number sensor for running sensor. Petitioner with having the highest is allowed to every 15 days.
Yes, sir.
Till regular settlement must be made.
Yes.
The petitioner. So this Rajesh Bhagat, respondent number 4, is the respondent number 4 here also?
Yes, sir. Because he was giving the, well, settlement when my settlement was continuing by another.
Anyway, just a minute, just a minute. So where is the disposal of this case? Is this case still pending?
Now, that case was disposed of.
Where is the order disposing it of?
That matter I have mentioned in my affidavit. but
Mr.
order
Counsel,
is-
you see, I do not know why you don't seem to understand the question put by this court to you.
Yes, my lord.
The question put by this court to you was, where is the order disposing of that first case?
My lord, this is disposal, my
And
lord.
you said that it is here.
But order was not annexed, my lord. This is disposal.
So
Yes.
please answer the question. I have not asked you what you ate for breakfast today. I have asked you what color are your shoes. So I don't want the answer for what you ate for breakfast. I want the answer for what color is your shoes. Similarly here, the answer I wanted was, where is the order? And you said the order is here. Now you are saying that the order is not here, but it is in my, I have mentioned about it. Mentioning is not, where is the order?
Then I have to forget the order, my lord, because my lord,
You have to obtain the order naturally.
because my lord, one thing, my lord, that's
No, because you see that gives an idea to this court as to how the
Yeah,
case started.
I can bring the.
How big is the order?
I can bring the order.
Yes, Briganko. Just see this 3400/2024. Have you got the order?
Yes, sir.
How many pages?
Okay, repeat it.
Then print it up.
It is for the order.
3400/2024.
Since the land valuation certificate was cancelled by the circular officer, so crossing next.
No,
Page 95.
95. Yes, sir, 95.
Yeah, next it.
He is saying that he is not annexed.
Yeah, next is 3400. Am I right? No.
Yes,
This is annexed.
Yes,
It is annexed.
Yes, yeah, my lord.
Ah,
Thank you.
just a minute. Page 95 is there.
Yes, that is there.
Okay. So out here, the Speaking order,
This is next page, my lord.
8/7/2024. Land valuation certificate. Cancel. This is a page
Page, my lord, this is 98
98.
and except 23.
Whereas one number of land valuation certificate has been by, what is it, has been what? Has been submitted,
Because covering the only land, my lord, only one.
has been pertaining, you said three.
No, later on. that one-
Initially, you had said three.
No, this is what different, my lord. This is land valuation certificate and another tree is but a non-encumbrance certificate.
Okay, no, no. Has been pertaining for land measure sensor. And we should from pay for casting. It was found that there is a discrepancy between the land schedule mentioned in the application and the lot Manda's report. Further, a thorough review of the documents revealed that the land valuation stated in the issued certificate differs from the valuation in the lot Manda's report.
Yes, ma'am.
Clerical error occurred during the typing of the certificate. Consequently, the certificate sensor stands scanned.
Yes, ma'am.
Okay, so it's cancelled.
Then after my lord, lordship come to the next page, my lord. Immediately, that was cancelled on my lord, 7 July. And
8 July.
8 July, then again, my lord, on 26 July. 26 July, annexed.
No, that is a different thing. It may have been corrected subsequently, but at the time you had submitted your bid. It was not a correct
my lord,
document.
This
And-
is my lord.
No,
kindly come
let us know one thing. As per the NIT
Yes,
of 8/2/2024,
yes, sir.
what was the last date of submission of bid?
This is 29 February 2020.
What was
29 February.
uh, what is the date?
29 February.
29 February 2024 was the last date of submission of it. So on 29/2/2024,
Yes, ma'am.
you are supposed to have everything in order. What you had subsequent to the last date of submission, it does not count.
My
That's
lord,
all.
well, think
So
is that-
then, no. Let me get the facts clear. Let me ask the question first, then I'll give you all the time in the world. So, in the case of 4177
Yes.
of 2024, what have you put to challenge? Let us see
Because
your
of the-
plan.
after immediately issuing of this one, cancellation of this land valuation certificate, the authority concerned has again issued the free land valuation certificate in my favor.
No, the land valuation certificate issued to you
Yes.
on
6.
26/7.
Yes, madam.
26/7/2024. So land valuation certificate
In respect of same land.
issued, correct one issued,
Yes, correct.
correct land valuation. Now, correct land valuation certificate issued. So on the basis of this correct land valuation certificate, you have filed this writ petition.
Because I approached the representation, they are not considered, so that is why I filed the petition. Second,
And what are the prayer? Let us see your prayer.
Page 33.
33.
Then why have you filed the present writ petition?
Because my lord, during the pendency of this, my lord, the second writ petition, whenever my lord lordship has given a direction to verify whether the land certificate, valuation certificate issued earlier, which was cancelled, and the subsequent land valuation certificate is the same one, or in respect to the same land. During that pendency, my lord, the authority has come with a under order, but settling the ferry service in favor of the Response number 4, my lord. That is why the third petition.
First case also, the settlement was. Settlement with you was.
That was temporary. No, let me finish.
Final order.
My let me finish first, then we'll cut time management for me this.
Yeah. Must be, must be a lot of fees involved, money involved.
Well, at the first one, well, the temporary settlement. This is not a permanent settlement, by the way. Which was Lordship was pleased to stay. And
That was the disposed of case.
that is disposed of. by the way.
Disposed of case of 15 days.
Yes, madam.
Then the second
Second
petition.
petition, because well, they have come with the cancellation order. So whenever the new land valuation certificate is issued in my favor, then that was
No,
not
no, but
considered.
out here in a second.
Second, my lord, yes. 4177, I have challenged this thing, madam. Because I want a settlement on the basis of my new land valuation certificate.
So you have challenged the recommendation for settlement of the ferry with the
Yes.
respondent number 4.
Yes, allow it. But the third one, my lord. I have
That one
challenged-
is for what?
But third one, my lord, I came after final settlement in favor of the respondent number 4, my lord. Because my lord, my stand was that, but as my lord, they have received the document regarding the land cancellation valuation certificate was cancelled, which was not accepted by by any process of official my lord correspondence. This is, I don't know where from this has come, and this is purely belongs to me, that communication.
Okay, so that is your case. Yes, got it.
But this, whenever the same authority has again issued the same land valuation certificate, and in that aspect, the respondent number.
You mean to say that this page, let us see your earlier land valuation certificate.
Yes, ma'am.
Was there any difference?
No, no difference, ma'am, at all.
Let us see.
Earlier was, it is on page 23, man. I know, 98, man. And
Huh?
except 23.
No, no, no. It cannot be 98. 99 is the new one.
No, 98, man.
Huh?
98 is the old one.
98 is cancellation of your valuation. Where is your valuation
I-
certificate?
earlier, Yes.
Why are you not understanding the
No,
question?
no, I'm sorry.
Selective amnesia.
That was, my lord, submitted with them, my lord. This is,
Whatever, you might be having a copy. Or have you given them the original?
I have given you. my lord,
When people ask you for documents, do you give them the original?
This is, my lord, the online submission was there, my lord.
So in online, how do you give original in online mode? Please teach me also.
This document is not there, my lord.
Not there, why?
But NEC are there, non-income certificate are there.
You have got everything but the most important document. The earlier land valuation certificate was dated, what was the date?
February.
22 to 24.
Yes, my lord.
22 to 24. And the corrected one was July 24.
July 24.
What is the difference between the two?
Honorable Court is right, if the government clarify what is the difference, that they have issued the land valuation certificate, they have filed their affidavit.
What is the difference?
Earlier, it was some clerical error.
Correct, but where is it? You see, there is a clerical error. Where is the clerical error?
I have explained in the paragraph 4.
Paragraph 2,
Paragraph 4, they have mentioned.
121.
page 121.
Yes.
Yes.
Yes, madam. Valuation was issued to Biju Chandra Das, madam,
Huh?
earlier, madam.
Page 121 is affidavit of Sushmita property.
This is, my lord, that's one number 5.
That's one number 5, affidavit, madam.
That's point number 5. But why don't you paginate your pages as per the court record?
In WBT, madam, 4349.
Huh?
4349.
I've got 4349.
Yeah, you can say,
That's point number 5. Okay, page 173. 173. Hare Krishna Deka. Is it Hare Krishna Deka?
Yes, my lord.
Yes.
Page 173.
Yes, one second.
Yes, para?
There are 4, my lord.
Para 4. These records have been corrected only in October 24.
Yeah.
This is prior to that, it is not in your name at all.
No, my lord, this is there, my lord, the record they have not corrected in their office.
No,
Because of that
even,
reason-
even the document.
But rely to that, my lord, I have filed one affidavit additional, my lord, where it is, I have specifically annexed.
It
the
was
Sabhavati-
your duty to have the documents corrected in your name.
My lord,
The
the,
objector was not made party.
no,
The
no,
person who
objector, what is the meaning?
That was not made party.
The objector, why I should make party, my lord, him?
No, Mr. Kaushal. How could you have been given a land valuation certificate when your name is not even there in the record?
The record, their name was there, my lord, my sale deed was there, my lord. Everything was there, but in spite of my, in continuation of my name, the other record holder also named there. This is the minor reflection is see. That though my name was there, but other record holders are there, that is why that has been corrected. Out of which, my lord, 2 bigger land I have purchased by a registered sale deed. And the valuation of.
Bearing sense is recorded in the name of Sachindra Nath Sarkar.
Yes, my lord.
But in record, the name of Sachindra is not recorded. As per the Daritri record name of Binod Daishya, daughter of Hare Krishna Daishya, was recorded as Patadar. And Bidur Chandra Race was recorded as occupancy tenant.
Yes, my lord.
You are an occupancy tenant.
No, my lord, this,
You are not the Patadar at all.
that was corrected, my lord.
Corrected in July 24.
But the thing is that, my lord, why should I suffer for this because of the official fault, my lord? Because this has been issued by the authority concerned. And this is their duty, my lord.
When you were given the earlier occupancy land valuation certificate, didn't you notice that your name was not the Patadar?
But the NEC also, my lord, given by them, but non-cabinet certificate, my lord. But moreover, my lord, the one thing, my lord, their stand is the department that they want it is all documents to be by through online. So if it is online, their only refusing ground was that this cannot be accepted after the online is over. But the land valuation cancellation certificate, my lord, that is letter, that is offline, and on what basis they have received, why they have.
You see, when people ask you for a birth certificate, you have got to submit your own birth certificate. You cannot submit your sister's birth certificate or your father's birth certificate
No, my lord.
and then say later on, this was a mistake. I have now corrected, I have the correct certificate now, please accept. At the time you submitted your documents online, you should have corrected, you should have checked the land valuation certificate, seen that it was in your name, and then submitted. But
No,
it was not. That's why you do not have that document here in your petition also.
No, this,
Usually read petitioners submit everything. They say that, look, this is what I had submitted. But unfortunately for you, you have got all the documents in your writ petition except for the main one, on the basis of which your case
No, my
hinges.
lord, this is, I have not concealed anything, my lord. Because, my lord, NEC,
Anyway,
my lord, kindly,
if you had given that,
my lord, kindly have a, my lord.
no, I've heard.
No, my lord, kindly see, my
It's
lord.
going to
three-
be, it's
No.
just going to be a back and forth.
No, my lord, this is not that, my lord, but I have submitted the three NEC.
No,
Non-income certificate, my lord, issued by the competent authority, as well as the land valuation certificate, my lord. It is not fraudulently I have obtained. It is not that I have.
I am not saying that you have obtained it fraudulently. I'm not saying that.
The authority,
What
issued, my lord.
I'm saying that you should have been careful. When supposing I finished my class, the 7 or class 8 exam, I ask them for my certificate. Supposing instead of my name, they give the name of some Bobby or something. And then I should say, that is not my name. Bobby is not my name. I'll tell them, please give me the correct certificate.
My lord,
You have not done that.
it is not that,
Don't
my lord.
really.
My name was very much there. They have mentioned my name,
Okay.
but the original document, they, where from they procured.
How do you say that your name was very much there?
My lord, I have a Jamabandi copy, my lord, the evidention affidavit. I have
No,
filed.
I want the land valuation certificate.
The land valuation certificate, my lord, they have issued on the basis of their document. I have not personally procured any document, my lord.
But you are the one who put it online, no?
No, I have.
You
my
are
lord,
the one who put
submitted
it on.
online, my lord. But I
Okay,
have
right,
personally,
right.
because
Heard
my
Mr. P.
application-
Mahansa.
My lord, kindly have a.
No, enough.
No, my lord, kindly, my lord.
Hearing concluded.
No,
That
my
is
lord, this
it.
is my lord, clearly, my lord, this is.
I heard
this is
Mr.
my
P.
lord-
Mahanta, learned counsel for the petitioners in both the writ petition. Mr. S. Kataki for respondent number 4 in both the writ petition. Ms. M.D. Bora, counsel for the, Senate counsel for the transport department, and Mr. Transport department. And Mr. M. Chetria for respondent number 2. Hearing concluded, judgment.
One second.
From the beginning.
My lord, I have submitted the salient points, but I have not referred to the.
He has not heard.
For my benefit.
Yes, for your benefit.
Now, your worship will kindly come to the.
So basically, the respondent number 7 is the 7th highest
My
bidder. You are the second highest.
second.
And the bid has been given, the settlement has been made with the respondent number 7 on the ground that all the other bidders and below him, higher than him, have quoted rates which are above 10% of the reserve price. Correct?
Right.
So your case is that in the NIT, there has been no condition that that a bidder cannot bid higher than 10% of the reserve price. And then the decision to give the respondent number 7, the settlement is based on a cabinet decision pertaining to the Panchayat department, wherein 10 bids settlement cannot be made in respect of markets where the bid is above 10% of the reserve price. And your case is that the decision made by the cabinet pertaining to the Panchayat department is not applicable to the present case, as the present case pertains to the municipal administration department. Correct?
Right.
And then further, the cabinet decision that has been made for the Panchayat department had resulted in the Panchayat department taking a decision that the cabinet decision would be incorporated into the NIT.
NIT, quite true.
Now, this has not been done by the municipal administration department. In any event, municipal administration department is a different department altogether, and the cabinet decision made for the panchayat department would not cover them. Correct? And then that in the pre-bid meeting that was held, there was no there was no discussion made with regard to a bidder not being allowed to submit, I mean, not being permitted to submit beyond 10% of the reserve price. And it was only for, I was only to discuss whether there should be an extension of the last date of submission of the bid by 1 day.
Yes.
That's all.
In fact, my lord,
Any other point?
to add to that, my lord, in the pre-bid meeting, there were, my lord, several members present. Out of those bidders, and out of those bidders, my lord, including the petitioner, had there been a discussion on the, my lord, 10% viability limit, then, my lord, they would not have placed, my lord, above, they would not submitted bid above 10%. And at least, my lord, 4 persons, they have, my lord, given bid higher than 10%. So it does not.
So how many? 4 bidders?
4, my lord. 4 bidders.
4 bidders have submitted.
H1, H2,
Have
H3 and
submitted-
H6. H1, H2, H3 and H6. They were, my lord, in the, they were
H2,
H1, H2, H3 and H6. H2 is the petitioner, my lord. They were present in the pre-bid meeting, and all these persons have, my lord, submitted bid higher than the 10%, my lord. Had they been, my lord, there, they are fighting tooth and nail in the court, and they are.
were they there in the pre-bid meeting?
My lord?
Was H1, H2, H3 and H6?
Yes, my lord, they were all present. Page 64, your worship will find there. And they were present, and as prudent businessmen, they would not have, my lord, given the bid higher than 10%. And, my lord, the pre-bid meeting, which was not, the condition was not there in the NIT, even if one of the assuming it to be held, my lord, where is the minutes? On the letter, my lord, the executive officer has said, my lord, there is no minutes. And we have filed an affidavit, my lord, and by many other participants, that in that particular meeting, nothing was discussed about the 10% that limit. And in fact, my lord, in the affidavit in reply, my lord, they have admitted that, my lord, there is
Okay,
no.
that is your submission. Now, any citations or
Yes,
something?
my lord. In fact, my lord, this condition, one judgment I have already annexed, my lord, in the writ petition, that your lordship finds at page 36. One more point, perhaps, my lord, I submitted, lordship, from reply. That, my lord, in the tender condition, there is a condition that, my lord, we have to charge the toll as per the.
As per the, yes, you have said.
Yes.
So that will be as per clause 9.
Yes, my lord. And therefore, we cannot, my lord, charge higher, and this is not, my lord, something speculative. And this judgment, my lord, page 36, by a court net bench of this honorable court, my lord, they discuss this, my lord, issue. And if your lordship comes to, my lord, page 37, your lordship will find the writ petitioner in that writ petition offered 13,53,600, serial number 2. Whereas the respondent number 6 in that writ petition, my lord, offered 12 lakhs, his bid was lower. Then, my lord, in paragraph 7, your lordship will find towards the last, my lord, 4 or 5 sentences, the honorable court discussed the rules for procedure of sale of pounds and markets by municipal board and town committees Assam. That has been discussed. Where, my lord, it has been stated that, my lord, the records, if the highest bid is not accepted, then, my lord, the reasons have to be recorded.
Where?
My lord, last 1, 2, 3, 4.
Page.
Page 37, my lord. Paragraph 7. Let me, my lord, read the paragraph 7. Mr. Rahman, the learned counsel for the petitioner, has submitted that the bid of the petitioner was found to be a valid one by the respondent municipal board authorities, and the petitioner's offered bid value was higher than the respondent number 6. Mr. Rahman has further submitted that after passing of the order of settlement dated 35/2022, the first higher bidder, namely so-and-so, by writing a letter dated 4/6/2022 addressed to the chairman Mongoldo Municipal Board, had sought refund of his earnest money, but the petitioner has not sought refund of his earnest money and challenged the arbitrary action on the part of the respondent municipal board authorities in settling the fish market in favor of the respondent number 6, who had offered a lesser bid value than the petitioner. Mr. Rahman has further submitted that Rule 7 of the Rules for Procedure for the Sale of Pounds and Markets by the Municipal Board and Town Committees in Assam has provided that though the settling authority in the respondent municipal board is not bound to accept the highest or any bid, but he does not accept the highest or any bid, he shall record his reasons in writing. Thus, there is a clear infraction of this statutory prescription contained in Rule 7. Then, my lord, your lordship may kindly come to paragraph 20 at page 42.
Page 42.
42. Paragraph 20. 20 and 21.
Paragraph 20.
My lord, 20 and 21.
Yes.
The respondent municipal board authorities have also failed to show that before institution of the competitive bidding process by the tender notice, any range had been ascertained and the same had been published and disclosed to the bidders, so that the bidders became aware before submission of their bid documents and before finalizing their bid value that in the event they submit bid higher value above the particular amount, the same would entail rejection. There was no upper limit prescribed by the respondent municipal board authority with the condition that if anyone offers a bid value over that particular amount, the same would entail rejection. Then 21, it is also settled that an administrative authority like a tendering authority is bound by the norms, standards and procedure laid down by it for the bidders in the tender notice, and later on, non-adherence to such norms or standards or procedure prescribed by it on its part at the time of accepting the bids would invalidate the action unless such deviation is based on some valid principle which is neither irrational nor unreasonable or discriminatory. In the matter of distribution of state largesse, one of the objectives is to secure the highest revenue for the state exchequer. If it decides to accept a bid which is not the highest bid and is likely to result in a loss to the state exchequer, it has to be on the basis of certain valid and rational principle. The judicial review of administrative action is intended to prevent such arbitrariness, irrationality, and unreasonableness. There is no whisper in the tender notice that at 27/4/2022, nor in the records of settlement that the municipal board authorities had laid down as a condition precedent that it would only accept a bid value which is nearer to the minimum value of the fish market fixed at rupees such and such. Fairness demanded that the respondent municipal board authorities should have disclosed all the bidders beforehand that the bid value above a particular amount or above a particular percentage of the minimum value so fixed would not be accepted. It was only when the time for accepting the bids came, the respondent municipal board authorities cited the reasons that the bid value offered by first highest bidder and the second highest bidder in the case in hand were not to be accepted. Then your lordship may my lord, come to paragraph 23. 22 also, my lord. It cannot be said that there was any delay on the part of the petitioner in approaching the court as he had filed the writ petition on 9/6/2022. Because here, my lord, already settlement order has been given and the private respondent has taken my lord over. When the writ petition was moved, the respondents were put to notice on 15/6/2022. While observing that the order of settlement would be subject to the outcome of the writ petition, the case record has revealed that the notices were duly served from the respondent municipal board authorities. Yet the respondent municipal board authorities have chosen not to file any counter affidavit till then 23. In the light of the discussion made above, this court is of the view, unhesitant view that in accepting the bid of the respondent number 6, whose offered bid value was the third highest among the 6 participating bidders by the respondent municipal board authorities, ignoring the 2 higher bid values offered by the other 2 bidders, including the petitioner, whose bid were also found responsive in nature. In settling the fish market, the respondent authorities were guided by irrelevant factors in the decision-making process, which also had a negative effect for the state exchequer. There was no public interest found involved in the decision-making process in awarding the lesser settlement amount, awarding the settlement of the fish market in favor of the respondent number 6 at a lesser settlement amount. In such view of the matter, this court is of the view that the order dated 35/2022 being an arbitrary is not sustainable in law. and is liable to be set aside, the same are accordingly set aside. Now, my lord, one thing, my lord, like to draw your lordship's attention to here in view of the fact that, my lord, I'm not the highest bidder. There is another highest bidder. What this honorable court did, my lord, thereafter, setting aside the settlement order, it has been sent back to the, my lord, authorities. Then, my lord, my instruction is that highest bidder is no longer interested, but then, my lord, I cannot vouch for that. So, it will be, my lord. Now, my lord, this honorable court have also, my lord, in paragraph 19, have referred to the, my lord, the Supreme Court decisions on that. Paragraph 19 will also be relevant, my lord,
Paragraph 19 now.
of this judgment, my lord, at page 41. That is regarding, my lord, that higher value. May I read that, my lord? In this
Wait,
context,
this also pertains to market, correct?
my lord. Market by
Well,
settlement by
that
the
Meghalaya case is slightly different footing. That's regarding a weighbridge.
that was regarding.
Weighbridge.
But there the point is, the point was that, my lord, the rate is fixed. For the waiveries, for private and government, but the rate
So
is,
here also the rate is fixed.
rate is fixed. Therefore, my lord, the public will not suffer. And the government will get the, my lord, higher revenue.
Anything else?
But this is, my lord, with regard to municipal board, my lord. This is with regard to municipal settlement of fish market.
Let us see the cabinet decision.
My lord, cabinet decision, your lordship will find at page in the affidavit in opposition, my lord, of the municipal board, page 61, running page 61. Now, my lord, even if this cabinet decision is to be, my lord, adopted, that has to be not by, my lord, the municipal board. It has to be by the, my lord, government in the municipal administration.
You mean to say 160, 166
166.
notification has to be issued.
Issued by the, my lord, government, and therefore it has to be.
It has to be acted upon.
All over the state, it will, my lord, it will be covered. But the thing municipal board independently, my lord, cannot say that we adopt it. Now, if your lordship will kindly.
Let us see page 61 is it?
61 is the, my lord, cabinet decision.
This one.
Page 61, my lord, with the photograph. Annex 2 of their affidavit.
And it should do, yes.
Ensuring fair price for markets and bazaars. In view of the concerns received from various quarters on bidding high price for settlement of markets, bazaars, huts, etc., and this resulting in higher rate of collection from the traders and public, which we cannot do, my lord. The state cabinet has declared to cancel the tenders for all markets, bazaars, huts, etc., which are floated by the Jila Parishad, Anchalik Panchayats, and Gaon Panchayats. So this is relating to, my lord, panchayats. The state government will float new tenders with the following conditions. The government value of the tender will be the average of the settlement value of the previous 3 years for the respective market, bazaar, hut, etc. Any bidder can quote a maximum of 10% above the government value of the market. Then any bid above 10% will not be accepted. PNRD, that's a Panchayat and Rural Development Department, will decide the modalities for selection of highest bidder in case 2 or more bidders quote the same price. So this is, my lord, only concerning the Panchayat department. This is also, my lord, fortified by the next document at page 62. This is also, my lord, issued by the Panchayat department, Panchayat and Rural Development. Pursuant to the decision taken in the meeting of the Honorable Cabinet held on 27/6/2024, the Governor of Assam is pleased to cancel the ongoing process of settlement of the huts, further fishery, etc. for the year 2024-25, for which NITs were already floated. Until the new tenders are finalized, existing lessors may be given extension at the relevant value for 23-24. As complaints have been received at various levels that the small tenders, vendors and other sellers in the hearts and bazaars, etc. are often exploited by the bidders who quote exorbitantly high bid price to grab the lease. The government of Assam is further pleased to make the provision that no settlement shall be made with the bidders who quote more than 10% of the average settle value of the last 3 years of these hearts, fisheries, pounds, etc. Accordingly, the new NITs will include the condition and such modalities NITs should be refloated for settlement of the hearts. Now, madam, this cabinet decision was of 27/6/2024. Our NIT is, my lord, January 2025. Had they been had they, my lord, adopted this last sentence, my lord, that the new NITs will include the condition, that would have been there. So, my lord, from June to
Your
January,
NIT is of which date?
NIT is dated 24th of January 2025. And the last date of submission was 12th of March. Now the minutes, my lord, they are talking about is at page 63. Page 63, annexure 4 is the minutes of the board meeting held on 5th March 2025. The last sentence, your lordship may read, my lord, skipping the others.
Yes.
Accordingly, based on the above reason, we unanimously decide to settle the Bhing Bazar Azgaon Hart for the year 2025-26 to any one of the responsive bidders, ensuring that the settlement value does not exceed 10% of the tender value for in our Bhing Municipal Board as per the Assam Cabinet decision on 27 June. Now, your lordship will find, my lord, these signatures of the members. My lord, had they taken this decision on 5th of March, the last date was, my lord, 12th of March. They could have issued a corrigendum. They have not issued any corrigendum. Instead, my lord, they say that we called the tender bidders for a pre-bid meeting on 11th.
This is on 5th of March.
5th of March. If, my lord, it were so, it was incumbent on the authorities to, my lord, to notify it and issue a corrigendum.
Just a minute. Give me the constitution. No, what did you say? This is 5th of March. So what are you trying to say?
What I am saying is that, my lord, last date was 12th of March for submission of bid. They could have issued a corrigendum on 5th or 6th, so that the bidders could know. And they, my lord, they want to say that on then there was a pre-bid meeting on 11th, so the one day before the last day. That minutes, that document they have annexed at page 64.
Yes, what? Page?
Page 64, my lord. 64 is the vernacular, my lord. I have given the type copy at page 65.
Yeah.
This is, my lord, purportedly the
Pre-bid meeting.
pre-bid meeting on 11/3/2025. Last date is 12.
Yes.
In today, page 65, your lordship will read, my lord, this is in assembly at page 64.
Yes.
Page 65 is the, my lord, typed one.
Yes.
In today's meeting, the chairman, deputy chairman, executive officer, head assistant and FNO assembled with the bidders as regard the discussion on the tender. Discussion on the tender. And my lord, these are the persons present and nothing more. And my lord, they have admitted, my lord, that there is no minutes. Now, all these persons, my lord, who were present, out of them, my lord, four have submitted bid above, my lord, 10%. Had there been a, my lord, decision that will not accept beyond 10%, then as a prudent businessman, they would have submitted within that limit. In fact, my lord, in paragraph 6, we have stated, my lord, in paragraph 6, my lord, they have, my lord, admitted 54,
That was 6 of
6 of this affidavit, my lord, of affidavit of the municipal board,
page 54.
page 54.
Yes.
Pursuant to the above decision and on the day before the last date of submitting the bid, the board held a pre-bid meeting on 11/3/2025, wherein the above decision of the board was conveyed to the prospective bidders.
What is the decision?
My lord,
That 10%.
10%. Because that was taken on 5th of March. That is in paragraph 5.
Yeah.
That document they have annexed. Your lordship has just seen that, my lord. In the meeting, the prospective bidders of Dhing Bazar pursuant to NIT dated 24/1/2025 were present, including the writ petitioner. In the meeting, the decision of the board by the resolution dated 5/3/2025 was discussed and was duly intimated to the bidders. However, the proceedings of the meeting were not recorded in detail except the signatures and phone numbers of the bidders. As against that, my lord, we have filed an affidavit. One additional affidavit, your lordship may, the affidavit in reply to their affidavit, my lord.
Yes.
There, your lordship may kindly come to my lord, annexure 9 at page 112.
Affidavit.
My lord, this is an affidavit shown by as many as, my lord, 9 bidders, including the petitioner, that we are the bidders in the and permanent residents of the aforesaid address and an Indian citizen by birth. This is true. That on 11/3/2025, we attended a pre-bid meeting with the chairman, vice chairman, head assistant, FMO, and accountant Dhing municipality arranged by Dhing municipality. This is true. That in the same meeting, although they offered a proposal to extend 1 day for dropping the tender, but the majority of the bidders had not accepted the said proposal, and accordingly, dropping of tender date was fixing on 23/2025, which was mentioned earlier. We have also, my lord, page 111, your lordship will find, my lord. One ward commissioner had asked about the response to the one later, my lord. With regard to that, page 100 annexure 8,
Page
111 of our affidavit in reply, ma'am.
Yes. That's all. Anything else? Any citation?
Now, my lord, some decisions, my lord. Dr. Says your lordship is aware of, my lord.
No, tell me. I don't know which paragraph. There's so many paragraphs.
I'll place, my lord. These are the, my lord, 3 decisions I'll place, my lord. One is Dr. Says, my lord, the relevant paragraphs will be 3, 4, 5, 6, and 7. More importantly, my lord, paragraph 4. Yeah, please. I'll not, my lord, burden your lordship and read paragraph 4, my lord. After hearing the parties were of the opinion that the entire process leading to acceptance of the appellant's tender is vitiated by more than one illegality. Firstly, the tender notice did not specify the viability range, nor did it say that only the tenderers coming within the viability range will be considered. This is the main reason on which It has been more significant, the tender notice did not even say that after receiving the tenders, the commissioner governor would first determine the viability range and would then call upon the lowest eligible tenderer to make a counter offer. Then, my lord, there are two division bench decisions of our court, my lord. Look at here. So what will be?
You give the both the orders to him, don't have to give it, otherwise he has got to walk 3 times.
Yes, sir, no, my lord, this is the last one. The last one.
Together.
That's it.
Yes, give it together. She's getting more exercise than she wants.
No, it's already there in the, my lord, on the record. They have already placed. It must be on the record already. my lord.
Yes. Which one? GLR?
They are both, one is JLR, one of JLR is Educom Solutions. The relevant paragraph will be paragraph 48 and 49.
48 and 49.
48 and 49.
What does it say?
My lord, it says that, my lord, the government authorities to notify the selection criteria in detail. May I read it, my lord? In paragraph 48, my lord, the accountability of the, my lord, tendering authorities, state government directly discuss. Then, my lord, paragraph 49.
I think 49 is the one you're relying upon.
Yes, ma'am. And the other is, this is a division bench decision, my lord. And the last decision I am placing is, my lord, 2011 5 ZLP 746. Makrab Khan.
Sarah?
It's a small judgment, my lord. In fact,
All judgment is still enough.
paragraph
Sarah.
12, 14 and 15, my lord.
Yes.
A reading of paragraph 12, my lord. A reading
Okay,
of-
what it is.
That's all. One ground, my lord, the private respondent has taken is that, my lord, we were a defaulter earlier.
Huh?
We were a defaulter earlier.
Okay, you're a defaulter.
But we are not defaulter. We have explained our affidavit. What happened, my lord? I was the existing lessee in the previous term, my lord. And the market was closed for 3 months. And we asked for remission. Then the authorities did not give the remission. We paid the entire amount.
You pay the, okay, so you're not a defaulter.
My lord, that's made clear by, my lord, please, 116. That's clear.
But you cleared the entire amount after or prior to the.
Right, right. My lord, that was in,
Since he has cleared the dues before the last day, therefore that point we are not discussing.
Yes.
Yes. My lord, my first point is there is a suppression of material fact in this case. The factum of pre-bid meeting, there is no whisper in the report. Now you cannot become wise now that this was discussed, that was not discussed. Fact of the matter is, you never disclosed this fact to the honorable court that there was a pre-bid meeting on 11/3. So, my lord, that is an aspect Lordship will certainly keep note of. Number 2, my lord, the petitioner is second highest bidder. Assuming, my lord, Lordship is inclined to buy the argument of the petitioner, he'll not get the benefit. The benefit will go to the H1.
H1, correct.
Who is not before your Lordship.
Correct.
So that is another aspect the Lordship will keep in mind. Now, my lord, Lordship will kindly take note of 2-3 dates. My lord, NIT was 24/1/25.
Yes,
Last date of submission was 12/3/25.
12/3/25.
12/3.
Yes,
And on 5/3, as by now Lordship has come to know, the board took a decision that they will like to adopt the procedure mandated by the cabinet in respect of Panchayat and rural development. And page 80 of our affidavit, my lord, is the minutes. Page 80.
yes.
The board discusses the settlement of Dhing Bazar Adgaon for the
Page
year,
80, page 80 para?
page 8, no, my lord, it's that the minute itself. Page 80 of our affidavit, my lord, running page 80.
18, 18.
80. Affidavit of R7, my lord. It starts at page 65.
No, not in my compilation.
Number same, মই কৈছিলো তাৰমানে, equal হ'ব।
Why don't you compile as per the official report?
I'm sorry, one second. Page 71 of this. Millard, it starts at page 71, that affidavit. Thank you.
Yes, but
Please come to page 86.
yes, I think a junior should compile the paginate as per that.
Correct. Sorry, we'll be very careful in future.
So it becomes a problem.
Yes, page 86.
Yes.
The board discussed the settlement of Dhing Bazar for the year 25-26 based on Assam cabinet decision held on 27/6/24, which states the following points. Any bidder can quote a maximum 10% above the government value for the market, bazaar, ghat, etc. Any bid above 10% will not be accepted. And also it is been seen that due to high bidding price for settlement of market, bazaar, ghat, etc., this results in higher rate of collection from the trader and public under our ULB raising various concerns. Accordingly, based on the above reason, we unanimously decide to settle the Dhing Bazar for the so-and-so to any one of the responsive bidder, ensuring that settlement value does not exceed 10% of the tender value in our Dhing Municipal Board as per the Assam Cabinet decision held on so-and-so. So this was an unanimous decision of the board of the municipal board. That in the matter of, yes, it was not notified in the NIT. That's an aspect that we are not saying no. But there was a conscious decision taken by the board that any bid which is above 10% of the reserve value will not be accepted. So, my lord, to discuss this, my lord, now will kindly come to page number 88.
Yes.
A similar notice was issued to all, including the petitioner, my lord, his case of Kolita. It is 88. With reference to the subject cited in the letter, I have to inform you that a pre-bid meeting will be conducted on 11 in the office bidding of Similar notice was issued to all the bidders, and all the bidders attended. Now, my lord, what had happened in the pre-bid meeting that your lordships will now take note of. Now, my lord will kindly come to page number 74, my lord. 75.
It's fine. 75 is In your 75 or
Yes,
my
sir.
75?
No, lordships were 75.
Tara?
10,
Okay.
yes. Please come to the subpara.
Yes.
In this context, what had happened in the meeting, we have explained it. In this context, it is reiterated again that the Thing Municipal Board in its meeting dated 5/3/25 unanimously took a conscious decision to settle the market in question in respect of responsive bidder who has offered bid which does not exceed 10% of the tender value. It is therefore very pertinent to mention herein that tendering authority by letter dated 10/3/25 called the answering respondent to attend the pre-bid meeting scheduled on 11/3/25 at 11:30 AM in the office of the Thing Municipal Board. And according to the answering deponent attended the said meeting along with the writ petitioner who was also called to attend along with others through notices. The said meeting was attended by several bidders as well as some local public. Authorities at the commencement of the meeting informed about the agenda of the meeting as to what the authorities desired to extend the last date of submission of bid in view of the decision taken on the meeting dated 5/3/25 and certain other factors, but the writ petitioner along with some of his allies created an unholy situation by showing the disagreement to the decision of extension and adoption of cabinet decision taken. However, it appears that the bidders were duly informed about implementation of the decision of the board in its meeting dated 5/3/25 before the last date of submission of the respective bid. Now, what had happened actually, we thought, when this was informed that they all, many of them had objected. As a result, they left. So therefore, nothing could be minuted. And it is a fact, my lord, that this aspect was discussed and it was informed.
Where have you said that they have left?
My lord, no, they say they to become extension and adoption of the cabinet. However, it is no this line, my lord. But the writ petitioner along with some have created an unholy situation by showing the disagreement to the decision of extension and adoption of the cabinet.
There is nowhere shown that.
No, what I'm saying is, my lord, thereafter they left. Actually, authority wanted.
But then you should have clarified here that we tried to make, you have not said anything.
No, what
That the minutes of the meeting will be, are going to be recorded and they did
No,
not want to
no,
try
what,
it.
what we said is, my lord, it was explained to us, then there was a two issues. Because next day is the date. So whether there should be extension as well as this. Then, my lord, there was a.
No, I understand, but the problem is, this is a question of fact.
It's a question of fact.
Because you have not explained it fully also here.
No, my lord.
Because you could have said that we tried to make a minute of the meeting.
No,
but they did not want to sign.
First of all, kindly let me read the letter,
Yes.
also, my lord. The writ petitioner in the writ petition had not even whispered regarding his participation in the pre-bid meeting for which he was duly called for to attend by notice. It is relevant to mention that NIT contains no procedure of pre-bid meeting and therefore the said fact is material. But the same has been deliberately been suppressed by the writ petitioner so as to get an interim order. This is regarding suppression. And what had happened was this matter was explained to us. That's why we have quoted rated like that, my lord. Otherwise, why would they have done it, my lord? Not only me, others have also quoted. Now, my lord, there is an issue. Now, let us come to the. So, my lord, the issue is, yes, as a court exercising 226 powers, whether lordships will at all go into this aspect. So, in that case, lordship will have to relegate the petitioner to a suit. Lordships cannot decide.
Or we can send it back to the authorities. If we agree to his thing. No, you see,
Yes.
there is one aspect.
No, I'm coming, Miller.
No, just one thing. You see, whenever a notice when writing tender is issued, and a certain period of time is given to the authorities, to the candidates to submit their bids. Now, when you suddenly take a decision 1 day prior to the last day, saying that this will be the new norm. Now, can it be said that enough time has been given to them?
That is not their grievance. That is not their grievance.
No, I'm asking.
Or my lord, if
So
they
that
would
is
have,
coming to my mind.
Yeah.
If there is a new parameter to be put into the tender, which was not there at all from the very beginning. Giving 1 day time, I don't think it's usually given. It's even for a restricted tender. It's usually at least 3-4 days or a week or something is given. Now out here suddenly one fine day, the respondents wake up and they say that
No,
tomorrow's last day, today we'll have pre-bid meeting. And it
No,
should be
but
done.
it happens, my lord, in a commercial transaction, it happens.
This is a bazaar.
No, it's a bazaar, no, my lord, there's one more thing. Now, this settlement is governed by a statutory rule. I'm coming to that.
Now, what does the rule provide?
Yes.
What does the rule provide for giving time for tender? Is there any time limit for?
Yeah, it was 24/1.
No.
Wait.
24/1
last day was 12/3.
without the 10% parameter. That 10% over and above 10% will not be considered. That is not there in
My
the
lord,
condition.
my humble submission would be like this. My lord, you can respond to what has fallen from your lordship just now. Now, what your lordship is, suggesting is what should be normally a time for tender.
Correct.
I appreciate that should be minimum 15 days. Here it is from my lord 24/1/25 to 12/3/25.
But then that
No, I'm coming
condition.
to that.
Huh.
Normally, my lord, what happens whenever any pre-bid meeting intervenes, that sometimes it is 2 days, 3 days, 4 days, 5 days, it happens.
Correct.
So, my lord, normally a tender does not contain any provision as to from the pre-bid meeting what should be the ideal date. Yes, reasonable date is certainly more than 1 day. That I'll never say no. But in the facts of the case, if somebody comes with a grievance that 1 day was too late, then in that case, lordship will take a call. But lordship will not generally take that call.
But here there is no provision for pre-bid meeting.
I'm
Also.
coming to it. No, these are all, end of the day, without causing prejudice to anybody, the rules can always be devised. Now, my lord, rule 7 is the rules which govern this. Kindly have a look at this. Please come to rule 7, my lord. Because in the judgment of the coordinate bench, there also rule 7 is referred.
Yes.
Every bid made shall be recorded in writing by the officer conducting the sale. He shall not be bound to accept the highest or any bid. But if he does not accept the highest bid or any bid, he shall record his reasons in writing. The lease shall be granted to person whose bid is accepted subject to the provision of the succeeding rule. So, my lord, kindly come to now the settlement order. 86 or 85. Now, please come to page 91. Our affidavit.
Yes.
Yes, page 91. Kindly come to the agenda. Settlement of Dhing Bazar for the year 2025-26. Discussion and resolution. Board decided to settle Dhing Bazar for the year 25-26 based on the resolution dated 5/3/25, ensuring that settlement value does not exceed 10% of the tender value. Accordingly, with the majority, the board agreed to settle the market with R7 bidder C. Praveen Nath as per the previous resolution of the board dated 5/3/25. Board has decided to settle so and so. Well, this is not under challenge. Neither 5/3 is under challenge. So, my lord, this decision is strictly in consonance with Rule 7.
The board has decided to give a settlement of so and so to H1 bidder.
H7.
H1.
H7 bidder.
No, come to the number 2. This parking.
Oh, parking. So, we are concerned with
Wow.
agenda 1, not agenda 1. So, my lord, with my humble submission, at end of the day, my lord, what is a tender? In Ma Binda's case, Honorable Supreme Court says it's an offer. And end of the day, it is also a commercial transaction. Now, my lord, let me place that judgment of the Supreme Court in Mabinda. Uh, 2014 3 SCC 636. Oh, sorry. Sorry, my lord, 760.
Para?
Para 8. Yes. Please come to para 8, my lord, at page number 4764. This scope of judicial review, as the lordship got it. Scope of judicial review in matters relating to award of contracts by the state and its instrumentalities is settled by a long line of decisions of this court. While these decisions clearly recognize that power exercised by the government and its instrumentalities in regard to allotment of contract is subject to judicial review at the instance of an aggrieved party, submission of tender in response to a notice inviting tender is no more than making an offer which the state or its agencies are under no obligation to accept. The bidders participating in the tender process cannot therefore insist that their tender should be accepted simply because a given tender is the highest or lowest depending upon whether the contract is for sale of a public property or for execution of works of the government. All that the participating bidders are entitled to is a fair, equal, and non-discriminatory treatment in the matter of evaluation of their tender. It is also fairly well settled that award of contract is essentially a commercial transaction, which must be determined on the basis of consideration that are relevant for such commercial decisions. Now, here in this case, my lord, what is that unfairness which has been caused to the petitioner?
You see,
Having regard to the decision taken on 5th.
one thing is the preconditions or the conditions that have subsequently been decided to be imposed on the tenderers
Yes.
have been made known to the petitioners or to the bidders only one day prior to the last date of.
Yes.
That is the thing. So that
No,
I find
my
not
lord-
to be fair.
My lord, absolutely. Well, I'm sorry, in a given case, it could be. But here in this case, because it is nobody's grievance, neither it is the grievance of the petitioner for this
No,
decision.
but
No,
that
no,
is what I'm
no,
thinking aloud.
not sir. My lord, my humble submission is, even the judgment which my learned friend is relying, the coordinate bench, please come to the judgment for a moment. Please come to that judgment at page 42. Please come to page 42. Para 21, 1, 2, 3, 4, 5, 6, 7 line from bottom.
Yes.
My lord, this honorable coordinate bench did not rule out a situation where there could be some condition imposed in between. That's what, this is the portion. Fairness demanded that respondent municipal board authorities should have disclosed to all bidders beforehand that the bid value above a particular amount or above a particular percentage of minimum value so fixed would not be accepted. It was only when time for acceptance of the bid came to the respondent municipal board authorities cited the reason that bid value offered by highest bidder, etc. What had happened, my lord? Here prior, before it was not in mention. At the time of taking the call, it was mentioned. When the decision was taken, beforehand it was not done. So even this honorable court has visualized the situation that in a case of this nature, if you inform it beforehand, then it is permissible.
But not informed within time.
Anyway, it would be my duty to persuade your lordships, since nobody has come up with that, grievance. So that cannot be.
No, you see, because their grievance is that in the pre-bid meeting, the issue of that 10% was not discussed, only one day
It
was
was discussed, my lord.
According to you, it was discussed. Now,
Even according to the authorities affidavit also.
probably it was discussed,
Yeah.
probably it was discussed. But in the absence of any minutes being recorded,
Yes.
it is very difficult for this court to come to a decision whether it is this way or that way. Because I'm quite sure in the official records also it is not there. If it is not there here, it will not be there in the records also. But
Yes.
otherwise they would have produced it. So having said that, now when you are going to make a bid involving a crore or maybe 80 lakhs or 70 lakhs, which is going to pertain to a market which is going to sell everything, from your dal to whatever. So I think one day is too less to make a calculation of all the items to be sold.
No, my lord, ideally, my lord, what your lordship is saying is absolutely correct. That will depend upon the facts of each case. But here in this case, if anybody would have come up with that grievance, yes, certainly lordships will invoke that power. But here it is nobody's, on the contrary, they have suppressed. On the contrary, they have projected the case as if out of the blue it has been done. Now, lordship is having some doubt because it was not minuted. That is an aspect which I leave it to lordships to take an appropriate call. But when you look at the entire things, my lord, how they are prejudiced me. End of the day, it's an offer. They have given an offer. We are not bound to accept it. Yes, we cannot reject it for an irrational reason. We have given a rational reason. My lord, it is not that his tender has been rejected for a ground which is irrational, which does not appeal to your lordships. It does not satisfy your lordship's concerns. Yes, ideal situation, maybe 2-3 days would have been made it more conducive. But that is not his grievance. Therefore, my humble submission is, my lord, here is a case, and on top of that, lordships will also keep note of fact which I started at the very beginning. It's H2. If at all the benefit of this goes, it will go to H1.
It will not go to him. It will be decided by the authority.
So my humble submission is, my lord, I don't think any prejudice has been caused to anybody in this case. On the contrary, if the petitioner would have come up with a statement that there was a pre-bid meeting, but there is no clarity, then we do not know what view lordship would have taken on the very first day. So, my lord, therefore, now they cannot become wiser. After we pointed out that there was a pre-bid meeting, now they cannot become wiser and say, no, this was not minuted, this was not done, that was not done. This is absolutely not done with them. And my lord, it is a, my lord, market where some, my lord, fruit, vegetables and grocery items are sold. I don't think it's a rocket science that they require a lot of time.
No, I don't know, but then I know that there's a lot of money involved.
No,
A lot of money involved, keeping in view the top-notch lawyers that are appearing on either side.
There's nothing like it.
Oh, yeah,
Yes.
unless they are doing
When
it
we
pro
say-
bono.
My lord, when we say top-notch lawyer, well, in Delhi, we mean something here. But in this part of this country, my lord.
No. Selection.
Yes.
Okay, the settlement order is of 21-3.
Yes. And my lord, I'm relying on one judgment,
Yeah.
one paragraph. My lord, I'm relying upon the judgment. Year 2023 SC 2717. Sir.
One?
My lord, year SC 2717. I'm giving the top. My
Yeah.
lord will kindly come to para 48.
Tata Motor.
Yes, please come to para 48 at page 11. This court, being the guardian of the fundamental rights, is duty bound to interfere when there is arbitrariness, irrationality, malafide, and bias. However, this court has cautioned time and again that courts should exercise a lot of restraint while exercising power of judicial review in contractual or commercial matter. This court is normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made up. So, my lord, these are the limited grounds on which lordships will interfere. Now, in the absence of any pleadings and submission on behalf of the petitioner that he is prejudiced, that itself shows, my lord, there was no arbitrariness. Not to speak of, it can be malefice, it can be irrational, it can be bias, but to bring in the point of arbitrariness, my lord, or violation of Article 14, if had it been his case that in one day was not good enough for us, in which event it would have been a different situation. That is not the case. And secondly, my lord, he could have challenged that also. Since he is relying upon the coordinate bench judgment of this honorable court, he could have challenged the NIT on that ground. That how come you are now bringing in a condition which is not there in the NIT? You have participated, you have submitted to the jurisdiction. And my lord, I have already paid 25% and 2 installments. No? Since there was no stay order. Of course, my lord, it was made clear that it will be subject to outcome of the case. I have paid 2 installments and then 1%. 25% of the case money we have already paid. 20 lakhs. Therefore, in my humble submission, my lord, it is not a case where the petitioners can claim that he has suffered any prejudice on account of any other claims. He could have challenged the NIT, he should not have participated in the bid if he is so conscious of his rights. And that suppression part definitely lordship will take note. That is my humble submission. I'm deeply honored.
No, 1 minute, my lord, if your lordship.
Yes, what about that suppression part?
My lord, that is what I was addressing to.
With your lordship's kind permission, my lord.
My lord, the pre-bid meeting, which my learned friend says, my lord, would have suppressed, that is of no relevance at all for us. In the sense that, my lord, there that viability range was not discussed at all. It was only regarding 1 day extension, and that was opposed by most of them. It was not extended. Now, my lord,
So that's why I said, I do not know what was stated there. Because your stand is that it was only 1 day extension. Their stand is that because of the 10% limit that was going to be implemented, whether there should be an extension of the time period. So we do not know.
my lord, there is
I do not
nothing
know.
about
That is
issue,
not,
my
that is why, though
No,
it
my
might
lord,
not, I'm just saying,
there is one statement that, my lord, that was the point that was discussed.
that
is a
I've not
statement.
made any decision. I've not made any
That is a
finding with
wording.
regard to whether the 10% was discussed or not. I have not said, I do not know. That
My
is,
lord,
that is
on
nothing.
that, my lord, on
The only
statement,
thing
they
is that,
say,
why they are saying that, what they are saying is that, why did you suppress that in your writ petition? That there was a pre-bid meeting.
yes, my lord, that's what I'm trying to address and certify lordship to. My lord, in that pre-bid meeting, which has been, my lord, we have in the affidavit in reply, we have annexed the document to show that, my lord, in the pre-bid meeting that the viability range was not discussed at all, and therefore it was not relevant. Why should I be, my lord, making submissions on irrelevant facts? It is only, my lord, they say that there was a pre-bid meeting, it was discussed on affidavit. Against that, my lord, 9 of the participants, my lord, they have filed an affidavit saying that the viability range was not discussed. Now, on their mere statement, your lordship will believe that, and on that ground, won't suit me.
No, I'm not believed. I'm neither here nor there. I'm believing, I've not believed either one of you, or on the alternative, I'm believing partly both of you.
My lord, there
Then neither here nor
of
there.
9 participants, and
You see,
your lordship will analyze the possibility.
This is not a court of evidence.
Yes, my lord. No,
So-
but then, your lordship may draw, my lord, some inference from the fact that had there been a, my lord, the discussion about 10%, 4 persons would not have, my lord, those who have.
I don't know. I do not know. That is speculation
They
again.
are not fools. My
No,
lord.
it may not be. I do not know. You all are so intelligent that sometimes you all can do things to fool the court also, to fool anyone. How do we know?
Not me only.
How
my
do
lord.
I know
Others-
what is in your heart and what is in your brain?
My lord, this is a statutory body and.
It
and
is,
your
it
lordship
is,
will
it
kindly
is like, section 106 of the Evidence Act,
No, your
where
lordship-
something happens in the secrecy of a house. And, as such, the burden of proof required
True,
to
your
prove
lordship.
that what happened inside the secrecy of a house is less. Because there's a proportionate burden cast on the persons inside the house to clarify that issue.
True.
So same here. Now both of you are saying something which I do not know what is
Now,
inside.
now, my lord, your lordship will kindly look.
I
into
was
it.
not in that pre-bid meeting. I don't know.
No, that particular fact,
So
my lord, your
you
lordship
have
will.
to you have to clarify.
No, your lordship will look into from another aspect. The other aspect is that, my lord, the municipality is not a government. They cannot take a decision on the viability report. That has to be, your lordship has already, my lord, pointed out 166. They are not the government, my.
No.
If that is adopted, that has to be adopted by the municipal, my lord, board.
You see, that issue we did not go into that issue because it was not there in the NIT. But the thing is that they have a right to follow whatever parameters they want. It is their tender. They can follow. The only issue is because it was not there in the tender, would they have done it? No, that's the only thing I'm looking at. And especially whether there was time enough to do. So tentatively, I think that 1 day is too less for giving time, even if we accept that 10% should be done. It's too less a time to consider. But they have got a right
My lord, that
to,
right,
to,
that right has to be from the, my lord, that has to be issued in the name of the governor. 166 article 1 comes into play, my lord. They cannot take a decision at the, my lord, municipal level.
no. You see, they have got a right to make their own parameters on how to select a successful
Yes.
tenderer.
True, but then but that has to be either in the tender notice or in the corrigendum, or my lord, everyone has to be informed. What is that document, my lord? That is not there. They are trying to improve their case now. And if the pre-bid meeting was held on 5th, my lord, they could have notified on 6th. They have not. This is all made up, my lord. They could have, they have taken the decision purportedly on 5th. On 6th, on 5th or 6th itself, my lord, they could have notified it.
Okay, let us hear the other side.
Right.
Let us hear the other side. Mr. Kane Chaudhary is not the only one against
Oh,
you.
yes. And clause 9, your lordship has noticed, my lord, that we cannot have our own rates, my lord. This is the rate fixed by the municipal.
Yes, you are appearing for whom?
For the municipal board matter, it's for number 3, 4, 5, and 6.
Is there any provision? Is there any rules which is being followed by the municipal administration board for grant of settlement of market?
Yeah, that one read by my senior colleague, mother. That rule 7,
Rule 7,
that was it, rules for procedure or sale of.
what is this rules? The rules for procedure
Yeah.
for the sale of pounds
Yes,
and
ma'am.
markets by municipal boards and town committees in Assam.
Yes, ma'am.
This is made under what? Is this a rule made under some provision of law? Or, huh?
Yes, ma'am.
It's made under,
It
under
matches
what?
147, 141, and 301 of Assam Municipal Act.
Where is that?
It's a notification.
This is the Assam rules of procedure in exercise of the powers conferred. Okay. This paper, this. Where's the problem is you all got everything. We don't have anything. Book. Yeah. Now, where is the provision for tender? Where is the provision for tenders?
The 6 refers to that auction
And 7 is the one. My lord, clause 3.
No,
my
no,
lord.
I want to know
Clause 3, my
what's
lord.
the procedure for publishing a tender.
Clause 3 says that sale by public auction.
Notice having been given 1 month previously. Huh? So you have to give at least 1 month's notice.
My lord, clause
Clause 3,
3, yes.
the sale by public auction of the right to levy fines and charges in respect of any pound and to collect the authorized fees in respect of any market shall be held. Public notice having been given 1 month previously.
Yes, now that's why NIT was issued in January, 24th of January.
Correct. So the conditions that are to govern,
10%.
yes, the selection process has to be also clarified in the NIT. And public notice having been given 1 month previously. Not later than 14th day of February. In the financial proceeding that this is to take effect. So out here, this has not been done.
That condition, regarding that condition, the lordship.
So when the statutory rules require 1 month time to be given, that should have been done. So the statutory rules could not have been superseded by a decision taken 6 days prior to the last date of submission of tender. And especially when the same has been brought to the notice of the tenderers 1 day prior to the closing of the tender. Then straightaway this goes.
The auction, that public auction was much more than 1 month, my lord, but that condition, which is now, yeah, as your lordship.
You see, when you talk about public auction, it means
As-
all the conditions
whole,
being
yeah.
included in that. The conditions for holding the public auction has to be there in the public domain for 1 month.
That your lordship has pointed out, that your lordship can. But here I just point out 2 things, madam. Everything I'll be adopting the submission of respondent number 7, madam. Now, lordship may kindly see first 2 aspects of the matter, madam. But the locus of respondent petitioner,
You just a minute. You are the
I'm for respondent for Dhing Municipal Board, madam, respondent number 3, 4, 5, and 6.
for municipal board.
Madam, 3, 4, 5, and 6.
3, 4, 5, and 6. Yes. What is your case?
Madam, 2 aspects of the matter, madam. First thing, your lordship is considering on the basis of the writ petition filed by the petitioner. Now,
Has to be on the basis of something.
my lord, what is this locus, my lord? First thing first, my lord, your lordship will consider he is H2. By any means, this is an academic exercise. He cannot get any benefit out of it.
He said that the H1 is not interested in pursuing
No,
the
he
matter.
cannot, his statement cannot, H1 is not.
No, he's saying your own. Why can't I accept it?
My lord, H1 is not before your lordship, my lord. That-
Anyway, supposing he succeeds,
my lord,
we'll send it to the authorities to take a decision.
my lord.
So that
Now, lordship kindly see, he has tried to make out a case. I'm placing one thing, my lord. The reserve price was 73 lakh 60,000. Now, he has quoted a price 1 crore 23 lakhs 53,000,
correct.
which is 68% higher than the reserve
Correct.
price.
So
It is exorbitant. Now, another fact which is important, my lord, he was the lessee in the previous term. And the previous term, his bid was only 74 lakh, my lord.
maybe
Now, this time, he has quoted 65% above than his previous term. So,
now what is the reason for rejecting his bid?
my lord, that is the reason, my lord. Yes, that is the thing only.
Let us see the reason for rejecting it.
Clause 8 of the NIT clearly mentioned that only because your bid is high, that does not give you the right.
Agreed. I agree with you fully.
Now, if your lordship comes to that resolution of 5/3/25 and also 18/3/25, page 91.
5325, we don't need to go into
Yes,
because
madam.
that's the same, that's
Page
the cabinet.
91, page 91.
Page 91.
This is the minutes of that where it was decided. Now, the board decided
to settlement the Dhing Bazar Adgawa for the year 25-26 based on the resolution dated 5/3/25, ensuring that the settlement value does not exceed 10% of the tender value. Accordingly, with the majority, the board agreed to settle the market to so and so as per the previous board resolution dated so and so. Now, Lordship, can kindly see, my lord, here, considering.
You see, you have only said that the respondent number 7 will be settled with the market.
No.
You have not given any reason whatsoever.
The 10% is there, my lord. It is within 10%. Highest 10%.
You see, the board decided to settle the Ding Bazaar for the years based on the resolutions ensuring that okay, only because of that.
10% only because of. Now, dear my lord, the cabinet decision specifically it is mentioned that there are a lot of complaints that a person makes a very high bid.
That's all right. That's all right. You could have easily cancel the tender and issue the fiction.
My lord, that could be. But Lordship, can
You can follow your own. You can have your own parameters for selecting a tenderer. But to suddenly, one day before the last day, you suddenly say no, this will be the parameter. You're changing the rules of the game. When the game has already been started, especially at the fag end of the game.
Well, that 10% he had no notice that your lordship has considered. I cannot improve this case. My consideration, my submission is there, my lord. His bid is apparently on the face of record is very exorbitant.
Maybe.
And that will cause a possibility of causing atrocities to the traders and the public, which has been referred to is the only reason for cabinet decision.
But you have not said that. You have only relied upon the cabinet decision.
My lord.
You have only relied upon the cabinet decision without giving him time to submit a fresh tender.
Well, for the timing, if you forget 10%, bid that reserve price was only 73,60,000 and he has quoted 1,23,00,000. His previous bid was 74 lakhs, my lord.
Correct, no?
Now, there is every possibility, my lord, the tendering authorities, they are the best judge. If it is very exorbitant, my lord, that does not give any right. I'll place one judgment. In the tender matter, public interest has to be seen.
Correct.
My lord, only because he has made out a technical ground.
So,
that may not be
so if he is going to give you more revenue,
that
just a minute, whether if he is going to give you more revenue, and if he is still bound by clause 9 of the NIT, which provides the rates which he can collect as toll, it is for everyone's benefit. Everyone will be laughing to the bank.
My lord, is very correct.
Except him.
Rate
So he is doing everything for the
but
public.
the rate is
according to
always
it.
fixed everywhere in regarding market. But atrocities take place because they do
That
it
is
to cover
where
it out.
that is where you have to step in and ensure that he's doing it as per the terms and conditions.
Every day, when the complaints were received and cabinet took a decision. We have just taken a logic.
Cabinet took a decision with regard to the panchayat department, not with regard to.
We have just taken the logic and we have just decided to follow that principle, my lord.
Okay, that's all.
Now I'll be placing one judgment, my lord. Only one judgment, restricting judgment, my lord. I mentioned the paragraphs also. It says that, my lord, in an auction matter, only public interest to be shown, only because he has made out a technical case of something, my lord, in the decision making process, that will not be looked into, my lord.
Okay, let me ask you a simple question. You want the estimated price for a contract work is 70 lakhs, like this. You publish a advertisement today and you say tomorrow is the last date. According to you, do you think that is fair, a reasonable amount of time given?
No, that you lost with.
So,
that is a
so in this case, you had a pre-bid meeting on 11th, telling them, according to you, telling them that 10% will be the limit. And the last date of submission of the thing is the next day, tomorrow, on 12th, same thing. And your reserve price is 70 lakh. You just said that, you just said that it is not fair one day. Here also, and remember, this is a market. He's going to sell, he's going to have a person selling dal, different 20 types of rice maybe, 20 types of wheat maybe, I do not know, tail or whatever, I do not know. And then, so he has also got to calculate. And vegetables, 1 day old vegetables and 6 day old vegetables, there'll be different prices. So all those things have to be considered.
My only submission is that, my lord, the decision which has been taken, on the face of it, his bid was exorbitant. And in the interest of public, in the public interest, my lord, this was taken, my lord. And he was, in any case, my lord, the H2, he cannot get it, my lord. So these two considerations, my lord, lordship will consider whether your lordship will now interfere with that decision-making process, my lord, on the basis of this retribution, my lord. That is the thing, my lord. If the decision being taken in a fair manner in the interest of public, my lord. Because his bid is exorbitant. Not only his bid value was 74 lakhs, my lord. Now, this year he's got, madam, that much.
Answer, why don't you understand? According to him, he has, you all have not said anything about the 10%. So according to him, he has done no wrong.
No, my lord. What
According to him,
I'm submitting, my lord, kindly.
Look, please, when you see, you are a government, you cannot think of things with blinkers on, blinkers, horses and all. Only this, what's happening on the side. You see, so you have got to think of his side of the story.
If your lordship, for the timing, 10% thing is removed, my lord, lordship kindly say whether there is the decision-making process and the decision has just been taken with it unfair. If it is unfair, your lordship will definitely. But if his bid is given, my lord, there is every possibility that atrocities will be done, my lord. It is too exorbitant, my lord.
Okay. Anybody else? Dear father?
No, he's gone.
Okay.
Done.
That's all. Now my part comes. Okay, right. Heard Mr. M.K. Chowdhury, Learned Senior Counsel, assisted by Mr. K. Kalita, Learned Counsel for the petitioner. Also heard Mr.
B. Chakrabarti.
B. Chakrabarti for the respondents number
3, 4, 5, and 6.
3 to 6. That is the Ding Municipal Board. Also heard Mr. K. Chowdhury, Learned Senior Counsel, assisted by Mr. B. Kaushik. It's point number 7. The petitioner is aggrieved with the settlement of the what market? Settlement of the what is the market name?
The name of the market is, my lord, is page 29, my lord, the first sentence. Settlement of Thing Bazar within bracket Athgaon Hat.
Okay, you got it. Settlement of Dhing Bazar bracket Athgaon Hat. Have it close now. With the respondent number 7. For a period of 1 year, effective from 1/4/2025 to 31/3/2020. Next part. The petitioners challenge to the settlement of the Dhing Bazar with the respondent number 7. No, this is the petitioners council submits that the settlement of the Dhing Bazar with the respondent number 7 by the respondents, by the state respondents has been based on a cabinet decision dated 27/6/2024, made in respect of the markets slash bazaars slash huts slash ghats, etc. under the Zila Parishads, Anchalik Panchayats and Gaon Panchayat. wherein it has been held that a bidder can quote a maximum of 10% above the government value for the market slash bazaar slash huts slash ghats, etc. And any bid above 10% of the government value would not be accepted. Next panel. The petitioner's counsel submits that the petitioner, along with others, had submitted their bids for the Ding market, Ding bazaar, pursuant to the NIT dated 24/1/2025. In the NIT, no condition has been stipulated which states that a bidder cannot bid higher than 10% of the government value fixed for the bazaar. Further, the cabinet decision which restricts submission of a bid beyond 10% of the government value of a bazaar has been made only with regard to the bazaars being run by the panchayat department and not in respect of the Deen bazaar, which is run under the municipal administration department. Next para. The learned senior counsel for the petitioner also submits that the panchayat department decision to incorporate the cabinet decision restricting the bids of tenderers to 10% of the government value of the bazaars besides not being applicable to the municipal administration department. The same was to be incorporated only. The same was to be incorporated in the NIT, notice inviting tenders, of the panchayat department. However, there is no incorporation of the cabinet decision in the present NIT, dated 24/1/20. He also submits that though the petitioner had not made any written averment in the writ petition with regard to the pre-bid meeting that had been held between the tenderers and the state respondent on 11/3/2025. The petitioner had attended a pre-bid meeting with the state respondents on 11/3/2025, wherein there was a discussion whether there should be an extension of the last day of submission of tenders pursuant to the NIT dated 24/1/2025. However, what happened? It was not done.
No, it was not done, my lord.
Why?
Many of the bidders objected to that.
However, as the same was objected by many of the bidders, there was no extension of the last date for submission of bids by the tenderers by 1 day.
And there was no discussion on my lord in person.
The petitions council submits that there was no discussion in the pre-bid meeting for restricting the bids of tenderers to 10% of the government value of the bazaar. So stop. Next one. Next one. The petitions council submits that though the state respondents have a right not to select the highest bidder, reasons have to be provided for not selecting the highest bidder. In the present case, the petitioner's bid was H2, while the bid of the respondent number 7 was H7. As such, the state respondent should have given justifiable reasons for not awarding the settlement of the market bazaar to H1 to 6. And instead of giving the same, instead of settling the same with the 7th highest tender. He submits that though the petitioner's bid is 1,23,553,000 as against the respondent number 7's bid of 80,93,911. The petitioner is duty bound to collect toll in terms of the prescribed rate fixed by the deemed municipal board, as provided in clause 9 of the NIT. He submits that the reserve price / government value of the market of the Ding Bazaar was 73,60,000. If the petitioner, if H1 or H2 was selected, more revenue would flow into government coffers without the successful tenderer being able to collect tolls beyond the rate fixed by the Ding municipal board, which would be in public interest. That is your case. Pushpa. The petitioner's counsel also submits that if the restriction on the bids of tenderers were to be limited, were discussed in the pre-bid meeting, H1, the tenderers whose bids were H1, H2, H3, and H6 would have been made within the 10% limit provided for by the cabinet decision. On 27/6/2020. However, as no discussion with regard to the bids beyond 10% of the government value having been discussed, comma, the tenderers will bid, the four of the tenderers, no, various tenderers have submitted bids beyond 10% of the government value. Next paragraph.
That the minors have not been.
Okay, right, you write one more thing. The petitioner's counsel further submits that no meeting minutes of the pre-bid meeting held on 11/3/2025 has been made by the state respondent to show that the the tenderers were to restrict their bids to 10% of the government value of the bazaar. In support of his submission that the collection and settlement of the bazaar with the respondent number 7 should be set aside. The petitioner has relied upon the decision of the Supreme Court in the case of 1997, 1 SCC 53, 2006, 3 GLR 117, and 2011, 5 GLT 742. So in relevant decision of the Supreme Court and this court, in fact. That's all, na? Then, right. Mr. K. Chaudhary, no, Mr.
One more decision was there, madam, 2011 5 GLT.
One more. Page?
No, my lord, the one is, my lord, annexed to the writ petition.
That is the one.
Page 36.
Page 36. Page 36, sir. And in the case of Babul Das versus State of Assam. 2023 SCC online GAU 807.
And also, my lord, another different bench.
How many? You've given me 4 already.
Yes, 4, my lord.
4 is, huh?
4.
4 is enough. I've got 4. Even,
Sorry.
right. Oh, I've got a meeting. 1:15 I've got a meeting. I have to continue with the judgment. Otherwise, already one has been reserved. Then otherwise I couldn't have stopped the argument. So I'll continue with this judgment at 2. Correct. Mr. K. Chaudhary, the learned counsel for the respondent number 7. On the other hand, submits that there has been a suppression of fact by the petitioner inasmuch as he has not made any disclosure in his pleadings with regard to the holding of a pre-bid meeting on 11/3/2020. He submits that even if the petition was to succeed, the petitioner being H2, it was incumbent on the part of the petitioner to have implemented the tenderer whose bid was H1. he submits that the municipal board had taken a decision on 5/3/2025 to restrict the consideration of the bids of the tenderers to 10% of the government value of the bazaar. And the same had been discussed in the pre-bid meeting held on 11/3/2024. The petitioner, being aware of the decision to restrict consideration of the bids of the tenderers to 10% of the government value of the government valuation of the bazaar. comma. The petitioner cannot be now allowed to make a challenge to the selection of the respondent number 7, after the petitioner's bid stood disqualified. Next one. He also submits that in terms of Rule 7 of the rules for procedure for the sale of pounds and markets by municipal boards and town committees in Assam, 1958, hereinafter referred to as the Rules for Procedure, 1958. Every bit. No, the respondents are not bound to accept the highest bid or any bid. However, if the respondents do not accept the highest bid or any bid, the reasons for not accepting the same have to be recorded in writing. In the present case, though the petitioner's bid was higher than the bid of the respondent number 7, the reasons for not accepting the higher bids has been categorically spelled out when they have stated that where is that spelling out page? When they have categorically spelled out in the minutes of the board meeting held on 18/3/2025. That settlement of the Ding Bazaar would only be in respect of those bids which did not exceed 10% of the tender value. The then senior counsel for the respondent number 7 further submits that in terms of the decision of the Supreme Court in the case of Ma Binda Express Carrier and another versus Northeast Frontier Railway and other 2014 PSCC 760. The Supreme Court has held that the bidders participating in the tender process cannot insist that because a given tender is the highest or lowest, depending upon whether the contract is for sale of public property or for execution of works on behalf of the government, their tender should be accepted. All that participating bidders are entitled to is a fair, equal and non-discriminatory treatment in the matter of evaluation of the tender. He submits that as there is no public interest in the present case, given the fact that the award of the, given the fact that the settlement of the bazaar is essentially a commercial transaction, the challenge made to the selection of the respondent number 7 by the state respondents has to be rejected. He also submits that in terms of the judgment of the Supreme Court in the case of dash versus dash AIR 2023 SC 2717. What is that? Huh? Tata Motors. Tata Motors, huh? No. Yeah, did it. I did one. Na? The Supreme Court has held that courts are normally loath to interfere in contractual matters unless a clear-cut case of arbitrariness or malafide or bias or irrationality is made up. The contracts entered into between private parties are not subject to scrutiny. No, this is it. Mm, The courts should not use a magnifying glass while scanning the tenders and make every small mistake appear like a big blunder. And that though the courts Now, though the actions of the state are amenable to writ jurisdiction, this discretionary power of the courts, of the higher court, of the superior courts must be exercised with great deal of restraint and thought. The learned counsel for the respondent number 7 submits that when the appellants, when the petitioners have been informed that bids above 10% of the government reserve rates would not be accepted by the respondent authority in the pre-bid meeting. There was no infirmity with the rejection of the bid of the petition, which was beyond the decision taken in the pre-bid meeting. Next paragraph. Mr. B. Chakrabarti. Learned counsel for the respondents numbers 3 to 6 submits that the tenderer whose bid was H1 has not been made a party to the present case. Full stop. He submits that besides, he submits that despite the municipal board having taken a decision to consider only those bids which are within 10% of the government reserve price for settlement of the Ding Bazaar. The petitioner's bid was 68% more than the bid he had submitted during the last selection process. Correct.
68% higher than the reserve price
Whatever, 68% higher than the reserve price
and 65% higher than the
and 65% higher than
previous.
the previous year. He submits that the petitioner was the settlement holder of the bazaar on the previous year. And as such, the quantum jump of rates of the bid of the petitioner could not have been in public interest. He submits that the restriction put on the bids that could be submitted by the tenderers had been made by the cabinet in view of the fact that the settlement holders used to charge high prices from the persons who are making use of who are benefiting, who are making use of the bazaars, some of which eventually led to higher prices of commodities, thereby which resulted in which was not in public interest. Stop. Next para. The counsel for the respondents number 3, 4, and 6, 3 to 6. While reiterating the submissions made by the counsel for the respondent number 7, has also stated that the reason for not selecting the petitioner from selecting the petitioner's bid and the bids of the other tenderer has been clearly spelled out in the minutes of the board meeting held on 18/3/2025, wherein it was stated that the resolution taken on 5/3/2025 by the Ding Municipal Board wherein the cabinet decision was decided to be followed, comma, had been reflected. He submits that in terms of the judgment of the Supreme Court in the case of
Silpi construction,
huh?
Silpi construction. 2020-16 FPP.
In the case of Silpi Construction 2020 16 SCC 489.
Para 8 to 20.
My God. While exercising the power of judicial review in respect of contracts, comma, the court should concern itself primarily with the question whether there was any infirmity in the decision-making process and could not examine details of the terms of the contract which had been entered into between the parties. So further, the court should interfere only when, well, should interfere only in public interest.
Paragraph 15 method.
Look, Mr. Khan, I cannot put in everything. There's so many laws where 8 to 20. How many 8 to 20 itself? There are around 30 judgments.
Mainly paragraph 15 method.
So he also submits that. How is this applicable AFCON's judgment? How is it applicable? Everyone knows that they are the author. The issue is citing something else. The issue is you have put in a condition which is not in the NIT. You have put in a condition 1 day prior to the last day. No one is talking about the interpretation of the terms of tender.
If matter record that we wanted to accept that they did not agree, matter.
What is the minute? Right, stop. He accordingly submits that no case of arbitrariness, malafidis, or unreasonableness having been made out by the petitioner. No, besides the lack of public interest, the writ petition should be dismissed. I have heard the learned counsel for the party. I think that'll take some time now. I will do it. So many judgments they have given me. Both sides. I've got to now, it'll take time. Hearing concluded, judgment result. Huh? Which one? Yes, yes. No, not required, not required. Not required.
Unless.
I mean, see.
This ED, Senior Counsel ED core is appearing for the client who has filed an application.
Who?
for conflict.
Oh,
Senior Counsel BD Core is appearing for the client who has filed an application for impeachment.
Okay. What is the matter about?
It's similar, the technical bid of the petitioners was rejected.
With regard to construction?
It's a road project, Madam.
project. So when was it rejected?
Madam, the 2/4/2025, Madam.
Huh?
2/4/25, Madam.
2/4, or last month?
Last month.
2/4.
Last month, 2/4/25.
Today is first, so it's last month.
Document.
So it was rejected.
Rejected.
So final, the financial bid has been opened.
My lord, before my lord, financial my lord, bid was open, my lord, I had approached this court. This court has granted an interim order and also directed.
After the financial bid was opened.
No, I had approached this court before that, and this court has granted my lord, stay. And
So
directed-
financial bid opened or not opened? Open.
Yes, madam, this court has directed them to open the financial bid. It was open. The one person has been selected as L1, and since my technical bid was rejected, so it was not taken into
So
consideration.
where is the stay? Stay for what? There is stay.
Stay for not to issue LOA, not to issue LOA.
Not to issue LOA.
Thereafter, which order, I have also disclosed my rate,
You have disclosed your
my
rate.
rate. So
Your rate is lower or higher?
my rate is lower,
Lower.
His is higher than the
Estimate.
estimate.
His is higher than the estimate, yours is lower than the estimate. By how much?
Difference is about my 11 crores.
I'm not on 11 percentage wise.
Mine is 20.152. 20% below
20% below estimate.
estimate.
What does the CPWD manual say on that?
There's a clause, if it is unreasonable or abnormally low, in that case, they'll be asking the justification.
They'll be asking the
Justification.
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 So
In a similar tender, I have also put it same rate, similar rate, and they have asked me for the justification.
so here did they ask you for a justification?
No, here, I have been rejected in the
Technical stage. Okay, so that issue does not arise.
That should have.
So technical stage, it has been rejected on what ground?
Well, firstly, they have rejected that as per the clause of the tender, I am to supply to air compression.
Two air compression.
To air compression.
Compressors.
Compressions.
Compressors, not compression, compressors, yeah.
So, I have submitted the invoices to be submitted. I have submitted the invoice of one set. Which
Invoice of one set.
One set, which consists of two
Invoice of one set? You said invoice of one set?
one set.
One set of compressor.
Compressor, that is, this one set consists of one is trolley mounted compressor, another is tractor mounted compressor.
One is
Trolley mounted compressor.
trolley mounted, okay, that's all right. Second,
Another is tractor mounted compressor.
tractor.
Tractor. So these two are basically fitted in the tractor for the purpose of all spraying and etc. And
So the question is whether you have given two air compressors
lot,
or one.
lot,
That is a factual issue.
lot. There's altogether.
So one is you have to submit two air compressors.
Two air compressors.
Two air compressors. According to them, you have submitted how many?
According to them,
One.
I have submitted one.
One. And according to you, you have submitted two.
Submitted two.
And then
Now in the affidavit, they are coming up and saying that according to the tender condition, I have to submit two sets.
correct, at a two set.
Two sets.
Earlier it
And
was
while making a representation, because under this,
no, two sets means what? Does one set consist of two compressors or one set consists of one compressor?
one set consists of two compressors.
Two compressors.
Two compressors. One is tractor mounted, another is.
Okay, that is one.
That-
So whether it is two sets or
One set.
air or two sets, okay, two sets. Number two, one set consists of two air compressors.
That is one.
Okay, then number two,
Malad, under this clause, Malad, the clause 20, three, Malad, under the clause,
23,
under clause 23.5,
23
the
percent.
authority, Malad, while evaluating the technical bid, they may seek clarification from the bidder. It is up to their discretion whether to seek the clarification or not, Malad. Then, Malad, they'll Malad, upload the technical bid in the Malad, web portal, giving 7 days time for submitting any objection. And thereafter, they'll finalize the tender. So far as the technical evaluation is concerned, then they proceed for the opening of the financial bid. Now, they did not, in this case, they did not seek any clarification from me, but even then, within the period of 7 days, I have submitted my clarification, a representation I have submitted that this consists of two compressor. And not only that, I have also referred to another instance where one of the tenderer, submitted similar invoice of one set and the authority has accepted it.
No, so the issue is whether the NIT requires two sets of air compressors or one set of compressor, air compressor, which consists of two air compressors.
Gotcha.
I do not know
It
that
comes under, as I said, because,
as per, so they will be the best persons to interpret that
they have
clause.
another tender, they have already interpreted that one set suffice the clause of 2 months. That reference I have given in my
Okay.
representation.
Then number 2 point.
Number 2, they have said, one of the clauses that, in Annexure 6, to, the calculating the, bid capacity, one has to, mention all the ongoing, works. And which also includes if I have submitted tender in some bidding process where LOI may not have been issued, but I have been declared as a winner of that bid. That also to be mentioned. So far as I am concerned, I have become the L1 as per the portal in 2 of the tenders, two other tender process where I have been shown as L1 bidder. So far as Assam is concerned, which they are intending, there they have issued a letter on
Intending meaning this present case? No, different.
different. Because those are to be mentioned to show my liability to determine the bid capacity.
To see a financial soundness, basically.
How much liability I have?
Actually, financial soundness, if you have got more liability than your income, then someone is going to be in a problem.
So here bid capacity is required 44 CR bid capacity.
Bid capacity 44 CR. What do you mean bid capacity? You should have 44.
What is the tender value that they are saying that this is the bid capacity? One must have the bid capacity to execute a work of 44 crores.
44 crores.
44 crores. And my bid capacity goes about 3,000 crores.
3,000 crores.
Gotcha.
So this work is for 44 crores.
The present tender value is 44 crores.
3,000 crores. Big difference between 2 and 3.
No, my bid capacity is over 3,600 crores.
Over 3,600 crores.
If those are added also.
So what is the so what did they say about this? You don't have this amount.
No, they don't say. I did not disclose that particular where I have been shown as L1.
You did not disclose your bid capacity.
So I have, there is a chart, Annexure 6 is there, where all the ongoing works are to be mentioned. They are one work, particular work. According to them, I did not mention, though I have been declared as winner of that particular tender.
Okay, you did not mention that you were the ones with the what? The selected candidate or what? Selected tender.
But here I was not selected, though I was L1.
Okay, then third ground.
Third ground is that in this while showing this bid capacity chart, I have mentioned one work that I have executed as a subcontractor. The principal the total amount was something more than 305 crores. I was 49% to the extent of 164 crores. I have completed my lord way back in November 2024,
So you were given 49% of the work as a subcontractor.
49%.
So you want to count
No,
this
not that.
49% of your
Not-
as
not
a
that.
past experience? No,
Not that,
then
not that, my lord. There, my lord, though I have completed my lord 49% of the work in my lord November 2024 itself, the principal contractor could not complete the remaining work.
okay.
So according to them, this I ought to have been mentioned in another annexure, that is annexure A. And if the work is more than 305 crores and there is a delay more than 3 months, I am not eligible to participate in the tender process.
So you did not mention that you were a subcontractor in another work wherein the principal contractor had not completed the contract.
I have mentioned in my lord, annexure 6, but I did not mention in the annexure 8. But this did not come because it is the, my lord, so far as my part is concerned, 49% that I have completed way back in my lord, November 2024, 23. The principal contractor could not contract, so that liability should not be, my lord, given to me. And in fact, with those documents, I have participated in another tender.
Maybe they want to see how truthful you are.
No, because of that, my lord, whatever we have mentioned, but the liability is not on me. I have completed, and in fact, my lord,
Okay.
in another tender process.
Now let us go to the NIT.
In another tender process, with all these documents, whatever my lord, defect they are trying to show, I have submitted tender. They did not reject me on this count.
Maybe, but we will have to see one case at a time. Then we do not know whether the decision taken earlier was the correct decision or not. If it was the correct decision, you've got no problem.
Yeah.
If it was the incorrect decision cannot come to your aid.
Yes. So my lord will find the technical evaluation. He had an eye at the top.
He doesn't want to press, he wants to hear you.
Yes. My lord, the 104, my lord, is the technical evaluation, my lord, that is held on 2/4/25,
Yes, the page,
page 104.
that is the IA.
Oh, no, my lord, in the main writ petition.
I mean, page 104, that is for the NIT.
It is my lord, technical bid evaluation, my lord. For the present one, minute.
I want, you see, what I want, why I want to go to the NIT is I want to see what is the requirement
Yes.
regarding the air compressors. What does it
Yes,
say?
yes, that's what exactly I'm trying to. take
Okay,
your
that is
lordship.
that page,
No, no,
104.
that is not there, my lord. I'll take your lordship by my lord, this decision.
No.
Yes, lordship may come to my lord, cross, page 47. Page 47.
Yes.
My lord, lordship will at least find this, J, column J.
J.
Each bidder must undertake, number 1, list of equipment as mentioned in appendix 2, section 2, instruction to bidders, ITB. So this is at page 76. This is section 2, appendix to ITB. And the relevant requirement is at page 78.
Yes, page 78.
That's serial number 8,
Yes.
air compressor 2.
Air compressor 2.
That's no number, no set, nothing. 2.
So it doesn't say 2 sets. It
Just
says
say
2.
2 sets. Now, the one I have submitted is at page 120, 3.
Yes.
Manual file 123, this is the tax invoice. Royal model trolley mounted air, one set. One set.
Where?
In the middle portion, my lord. Description
One
of
set.
goods. Then quality.
Royal model R120 trolley mounting air compressor. Ah, so it is one set.
One set.
So it is not a, it says that trolley mounting,
Lodgement.
does not say tractor.
Lodgement. Well, this is, my lord, along with that, this, my lord, page 124 also I had submitted.
You have submitted 124, page 124. Yes,
This is a sales certificate, my lord, with regard to the tractor mounted compression. Well, this tractor mounted compressor, my lord, it is a part of the, my lord, it is fitted with the tractor, so therefore the dealer, and this need to be registered under the Motor Vehicle Act, my lord, while registering a tractor with this motor compressor that need to be registered. So normally the dealer issues this certificate. As they has issued to me, I had also submitted, though it was not required.
this is a sales certificate only. Where is the receipt? How much did you buy it for? Who bought it?
Well, this is 123, man, page 123. Well, the name of the buyer, madam, Tenor Engineering.
123 and 124 are different. Yes, correct.
Well, this one set consists of two, as I said, madam, air trolley and the tractor mounted, madam.
No doubt.
Trolley mounted and tractor mounted. So far as tractor mounted is concerned, dealer used to issue.
How can it be? How can, from where do you say that one set consists of two tractors, two air compressors?
You know, this is, well, the tractor, well, whenever tractor is, well, required to be applied with all these works, well, these two machines are required, so therefore they sell it together.
What do you,
One set.
what is, okay. So, no.
And this sales certificate, because it's a bigger machine and this required to be registered, well, along with the tractor under the well, Motor Vehicles Act, so that is issued. So far as the trolley mounted, this compressor is concerned, it doesn't contain any, the chassis number. Now this, well, similar set your lordship will find, my lord, page 115. Hundred and 15.
Yes.
There I am, well, this is one of the invoices submitted by another tenderer in respect of another tenderer.
Yes.
And this was accepted as compliance of those two numbers. So in my representation, I have referred to this, that in that case, you have accepted that and you are rejecting in my case. Or,
Well, I don't know how a tractor mounted compressor and a trolley mounted compressor can be said to be.
their requirement is two, because one on the vehicle and one on the trolley to be fitted.
You see, it has to be, both has to be trolley, it has to be pulled.
One is fitted in the tractor itself, another is in the trolley.
I doubt. You know how big a air compressor is? Have you seen an air compressor?
One, this tractor mounted is big, this trolley mounted is small one.
Is there any photo here?
But that I
This
don't.
is,
That
is actually correct, but there can be a tractor mounted air compression, and there can be a trolley mounted air compression. Means the trolley, you have to pull it, no registration required. If it's tractor, you must have, your lordship must have seen in the highway.
No, I've seen a lot of air compressors, that's why.
That is big.
But I've seen all big ones.
I think the trolley mounted is around 1 lakh rupees first and the tractor mounted is around.
It's 30,000.
1 lakh base quality is 1 lakh and the tractor mounted is around.
Okay, then. Okay, so you have got two air compressors, but it cannot be a set. Is it there? So there, I don't think there is a trolley, there's a air compressor set. It's sold individually, I think.
Malad, while buying a tractor, normally, malad, these two are, as I said, malad, air compressor they give. That is the general usual
No,
practice.
I
And
don't
that
think so.
malad, sale invoice in respect of the
I don't
tractor
think so.
mounted is given.
I don't think so. If you want one air compressor, why should you buy two? It's not.
No, it is two, my lord. One fitted with the tractor, as I said, is a bigger
No,
one.
that can be done.
And another one is the trolley mounted that is fitted with the trolley. So these
Okay,
two
anyway,
equal.
so according to you, you have got two air compressors.
Two air compressors.
Then-
And in fact, similar invoice has been accepted. That was malad 115 submitted by one Hati Borgo.
But that speaks of only one air compressor.
One set.
No. Where do you get that word set?
Logically,
It's not written anywhere.
no, well, this invoices, well, it is mentioned one set. Otherwise, it
Where? Let me see again. Page 123.
logically.
Where does it say set?
Well, in between, well, in the middle portion, the description of group, then HS and SSC, then quantity, one set.
Where?
In the
One
middle,
set. Okay, out here one set.
one set.
But then you come to 124, it doesn't say set.
No, that is, it is only for the well, purpose of registration under the motor vehicle. Only the tractor mounted trolley chassis number is given. Because that will be required for registration with the tractor.
Okay, then.
Well, this 115, or why I'm saying they have accepted this. Now only in my case, they have been trying to make out a different case, my lord. This 115, my lord, there's another one, Hatibura, he has submitted, my lord, this air compressor. He also submitted invoice for one set.
It's one piece,
One piece.
115.
Such it.
not set piece.
But a compressed machine set.
115 says one piece, doesn't say set.
No, my lord, in fact, my lord, air compressor, trolley type compressor machine set.
Machine set, but
That's it,
quantity,
one
look at the
piece.
quantity. Quantity says one piece.
One piece, madam. Well, this has been accepted in another tender by him. I have referred this that you have accepted this kind of in the another tender, so you accept mine. Now, what they did not answer to that, madam.
Okay, then second
That-
point.
Rather in the affidavit, they said, madam, it is two set is required in the affidavit. They said it is two set required, madam. If you look at see the madam.
Okay, now let us go to the next point.
Yes. Now, my lord, next point, my lord. That 105 year lord should come, my lord. Second is, my lord. Bidder has not shown one of his committed work in the existing committed as per clause 4.2.
Where, which page?
105, this second my lord, ground of rejection. That is with regard to the my lord, non-disclosure of that existing commitment.
Where are you reading?
Serial number 5, my lord, at page 105.
Okay. 105, 105. 510. The bidder has
Look.
shown documentary evidence of only one air compressor.
That is first ground.
Ah,
Then second ground, next line, bidder has not shown one of his commitment work in the existing commitment as per clause number 4.2 of the RFP. The bidder has become L1 for job number so-and-so on 24/12/2024 under PWD NH work Assam, which is not shown in the existing commitment. Now, your lordship may come to my lord, clause 4.2. Page 47,
right?
page 47. Page 47.
Yes.
Bidder who inter alia meet the minimum qualification criteria will be qualified only if their available bid capacity
Where
is
are you reading?
page 47, clause 4.2,
4.2. Okay.
bid capacity.
Ah,
Bidder who inter alia meet the minimum qualification criteria
Yes,
will be qualified only if their available bid capacity is more than the total bid value. Value as per clause 1 of NIT, that is 44 crores. The available bid capacity will be calculated as per following based on the information mentioned in Annexure 6 of Appendix 1.
where is this annexure 6?
Is at page 95.
Page 95. Yes,
The relevant will be page 96.
yes.
Here I have to mention all the existing work have been is under execution, and as in the clause 4.2 it has also been clarified that if you are a winner in a particular bid but LOI has not been issued, that also you should be mentioning. So this is the one, and I have submitted mine one at page 108.
Yes.
Relevant will come to page 110.
Yes.
According to them, I should have been mentioning that particular work with the value, etc. in this column. That I have not mentioned.
Where? 110. First, which one? Where were you supposed to mention?
In this one of the as serial number. Now I have.
Yes,
I have
with regard to with regard to which work?
The work with regard to which I have been
Selected.
As L1, but bid has not been accepted as yet.
As yet, but
No, not as yet, as on the last date of bid. So that I should have been mentioned.
so which work is that?
Yes,
What
madam.
work is that?
Yes, yes. That work will also be fine, my lord. It's 150.
Huh?
116, my lord.
Yes, 116.
This is the job number, my lord. 15/AS/2023/24/249. Third line on the subject. This LOA was issued on 21st February 2025. And my the bid last bid due date was, my lord.
Okay, for this work, Bajugaon to Jadal, you were given LOA, is it?
Only on 21st February. Bid due date was 10/2/2000.
You were given LOA on
21/2/2025.
And last date of submission of bid was
10/2/2025.
so they have said that you have not mentioned this.
My lord, as per the tender clause, even if the LOA is not issued, but I have been declared as L1 or my rate has been accepted as L1, in that case, I have to mention.
Correct. But you were declared L1 when?
But I have not, my lord. The date was, my lord.
No, Mr. Counsel, this is a very simple question. Question is, do you know when you were declared L1 in this page 116?
My lord, on 24/12/2025. 24. They have issued me a notice that your lordship will find, my lord. 24 can become also. They have annexed with the affidavit opposition.
I don't know why you're not answering straight away.
No,
If
matter,
you can
I was not confirmed, my lord. I was only confirmed on 21st February 25.
So prior to that, you did not know that you were L1.
I have, my rat has been shown in the portal as L1, but they have not accepted it. They have sought my clarification saying that this
No,
is.
I'm asking you a simple question. Did you know that you were L1 in this work mentioned at 116? prior to 21 to 2025.
My lord, I was L1 that I knew, but
Did
my,
you knew, when did you know you were L1?
my lord, it was prior to my lord, bid due date.
So,
But-
so,
but that- but that
so you were aware.
But that status has not been, my lord, confirmed by them. My lord. They have issued a notice. Because the requirement of.
But then you knew it.
No.
How did you know it?
4.2 clause 4.2 requires I should be declared as winner of the bid.
4.2. Let us see 4.2 again. Page
Page 47.
47. Bidders who intervene the bid will
My lord, last two words, Lordship may take up, my lord, this page 47 for this. Last two words. And
for this, yes.
yes, for this purpose, the EPC contractor include turnkey project,
What is the EPC? EPC means?
my lord, engineering, procurement and construction. Now B, my lord, that's the formula they have been saying, my lord.
Yes, yes.
Lordship may directly come to fourth line, my lord.
Yes.
For the sake of clarification, it is mentioned that works for which bidder has emerged as the winner of the bids, but LOA has not been issued as on the day before opening the financial bid shall also be considered while calculating value of B. Now, your lordship will. Now, affidavit in opposition, they have trying to say that they have informed me earlier. They have informed me.
Who has informed you earlier? PWD.
Yes. Page 191. Page 191.
192.
The word is I have to be winner, madam. They have to accept my rate, madam.
So
Now
we
the-
will have to clarify what is winner. Then let them clarify.
Yes,
According to you, what is winner?
they have accepted my L1 bid. One 91.
Yes.
Inviting reference to the subject cited above, it is to inform you that the financial bid for the above mentioned work has been opened on 24/12/2024. It is observed that the bid price quoted by you as L1 bidder is rupees 6 crore and odd only, and the same is 27.04% below the estimated cost put to tender. In view of the above, you are hereby asked to furnish the justification of the quoted amount for your bid as it is an instance of abnormally low bid within 3 days. So my rate has not been accepted. Now, my lord, the next page, I have submitted my clarification. Lordship will note, my lord, 27.04% low. Now, page 192, I have submitted my clarification. That is on 2/1/2025,
And last date was?
10/2/2025. In between until 21st February
Last date is 10 to 25.
25.
And this is 2/1/25.
2/1, I have submitted my justification. They have not clarified this, my lord, whether they
After
have
this, there's no communication.
no commission except the LOA that has been issued on 21st February after the bid due date. And nonetheless, my lord, in the tender document, in the clarification also I have, my lord, mentioned, in the tender document, I have given an undertaking that I have been declared as L1 in this particular bid. So while, my lord, technical bid was evaluated, even if they wish to, my lord, calculate my bid capacity, they could have done it or could have, my lord, sought some clarification. By way of clarification representation, I have.
Okay, that's next point.
Next. Model 105, again,
105?
that minutes of the, my lord, technical bid evaluation. Third ground.
Yes. Yes. Where is the third ground?
My lord, the fifth line, lordship may come, my lord, serial number 5.
The
Fifth line, my lord, last portion, that
bidder has shown.
bidder has shown one project in value of annexure 6, having contract value more than 300 crore, having delay more than 3 months from scheduled completion period. However, the work has not been shown in Annexure 8. Details ongoing work, hence bidder is declared as technically non-responsive as per clause 4.1J, 4.2 of the RFP and as per clause 1A Annexure 8 of the RFP. Now this, Annexure 6, madam, at page 101, 111, madam. Hundred and ten starts from 110. This 1, 2, 3, 4, my lord, your lordship will kindly see, my lord, 110 percentage of participation of bidder in the project. My lord, first is serial number, then name of the project.
Correct.
Then percentage of participation of bidder in the project. And then your lordship may come to my lord, serial number 7, value of works completed.
Yes.
Now, so far as the work they are my lord, saying, that is at my lord, serial number 8, space 111.
Yes.
Here I have said 49% approved subcontractor. This percentage I said not a full work, 49% as subcontractor.
So,
So the serial number 7, the works completed. Value of works completed, serial number 7. And it is 301.64 crore. Whereas my subcontract was only for 164. And this document I have submitted, which you will find at page 128. Now, according to them, here your lordship will find this serial number.
you being a subcontractor,
Lordship.
can you show your subcontract work to be your work?
Yes.
Because the work has been allotted to the principal contractor.
Lordship.
Now the issue is, say supposing there is a question of past experience required of a contractor. Can a subcontract work done by a subcontractor be shown to be a part of his contract work?
Yes. In fact, my lord, earlier this work experience certificate was rejected, my lord, by in number of my lord tender process. Then I had approached this honorable court, your lordship was my lord dealing with it, my lord, entire issues, and finally lordship has directed them to my lord accept this as a my lord work experience, and they have also accepted that yes, this is work experience. We will be accepting my lord henceforth. So thereafter, my lord, I have been submitting tender in respect of others. That is also not denied by him. So question is, my lord, here. Which you will find serial number 9 is the anticipated date of completion. That is the
Serial
whole
number
work.
9, there's no serial number. There's no serial number.
Column 9, sorry, column 9. Column 9.
Yes.
That in the page 111, it will be my second last. Civil completion date was 18/11/23 project. Under EOT, likely date of completion 31/12/2024. So it was supposed to be completed 18/11/23 and is likely to be completed in 31/12/2024. Thereby delay of my lord about 3 months exist. So according to the my lord, in Annexure 8.
No, it says scheduled completion date was 18/11/23.
Lordship.
Project under EOT likely date of completion 31/12/24.
24. So
that is more than a year.
No, my lord.
That's more than a year.
No, it's November, my lord. November 23 and my lord.
December 24.
24, lordship, my lord.
So more than a year.
Yes, more than 3 months. According to them, my lord, more than 3 months. If it is more than 3 months, then it has to be mentioned in the Annexure 8. So it is more than 3 months. This there's more than one.
Though you had completed your part of the contract.
I have completed November 2023. That certificate I have annexed.
So according to you, they have disqualified you with respect to the third ground.
That is, I have not mentioned in Annex 8.
Okay, you have not mentioned this in Annex 8.
8. That
Now,
is
where is Annex 8?
is at page 113. In the event that the bidder had failed to merit.
Yes.
In the event that bidder has failed to achieve the completion of any project within a period of 90 days from the scheduled completion date of the project, unless such failure had occurred due to force majeure or for reasons solely attributable to the authority, the bidder shall be deemed to be ineligible for bidding this project, both as the sole party or as one of the parties to the joint person. I have not mentioned here according to them because there is a delay more than 90 days of that work. You should have mentioned. If I would have mentioned, I would have been disqualified under this. That is their contention. My contention is that percentage is there in the annexure 6. How much percentage work you have done? That is, I said 49. How much amount you have done? There is 1 crore 64. The total project is mentioned there. Only for disclosure of the fact. But so far as I am concerned, the work experience certificate I have given 128, that is along with the tender document. And in fact, with this experience, with these annexures, I have submitted in the another tender, they have not objected to this. They have accepted that.
No, but then why
It
didn't
would
you,
have been
why didn't you give this information at Annex 8?
There, if I have completed less than if I have delayed more than 90 days, so far as subcontracting party is concerned, in that case I should have given him. But this delay is done because let's will see the
Now
amount.
this delay, whether this delay is your part of the contract work or the principal contractor's delay, is a question of fact.
No, it's a document is there.
Document is there. Where?
128.
128. Yes.
This is the work certificate, 128 given by the employer.
Yes.
Page 128.
Yes.
This is my subcontracting part of 49%. Detail of measure item and financial value of executed item as on 30th November 2023 as per Schedule B of the contract agreement are as follows. It is as on 30th November 2023. And the total amount your lordship will find this is 164 crores and odd. That is my subcontracting part. I have completed way back on 30th November 2023. And they have accepted this in other tender. They have not rejected. But here only to reject me, they have rejected me. These grounds have been mentioned.
No, but how do you say that this work that has been mentioned in page 128, that this is your work and not somebody else's work?
This is to certify that the construction of two so-and-so in the state of Arunachal under Arunachal Pradesh package of road and Himalaya has been awarded to Messrs. Joint Stock Association. Wide agreement dated so-and-so and 49% of contract value subcontract has been awarded to Messrs. Tenor Engineering registered so-and-so Arunachal Pradesh by Messrs. Joint Company Industrial Association for the by subcontract agreement dated NIT so-and-so in work has been executed as specified Schedule B of the contract agreement. Correct. Now this is total cost, total project cost is 334 crores.
Correct.
And odd. And I have completed 164.
No, but how do we know that? You have completed your part, your portion of the work.
Always,
Yes,
matlab, the
subcontract work.
subcontractor matlab, does this part, matlab, they have.
Always to forget it.
This has been, this is.
How do you prove that? Because that is what they're going to say.
No, they
Yeah,
are
how-
not going, they are not saying that.
They're not saying that.
They are
Then,
not saying.
then,
Because
then what are you trying to say?
But I am trying to say that I have completed matlab, on 30th November 2023. So any delay of 1 year or more than 90 days, it is the principal contractor. I have.
But how do you, that is what I'm saying. This page 128 and 129. How do
Well,
we know that?
As on the bid.
How do we know that this 128 to 129? This talks of value of work of 1 crore or value of work of how much? 164 crores. Is it?
This is 49%.
Huh?
49.
164 crores. 164 crores, 49%. And so this work that they're talking about in page 128, 129 is subcontract work.
Subcontract.
But where do does it say that this is subcontract work?
Yes, matlab, the first recitation I have matlab, said matlab, has been awarded to Messrs. Tenor Matlab as subcontractor. I don't know.
Okay. So according to you, this pertains to only your work.
This part, that has been accepted by them. It is not that. matlab,
That's not denied.
That is not denied. Only thing is the delay of that period. I should have mentioned there. But that is.
The delay that was occasioned due to the failure of the principal contractor.
He has, matlab, I have done 23, matlab, November 23. Now he is up to 12/24. He was, matlab, could not complete it.
Anything else?
And this court also, matlab, because of they, matlab, this question arose.
Anything else, Mr. Counsel? I will get back to you if it's otherwise we're wasting time. Anything else?
It's just a reference, matlab, this whether it is my work or others' work, they used to be rejecting earlier. So I approached this court. And after that, they started accepting that this is my work. I can use it as my work experience. So that is, there is no issue. And as I said, matlab, this similar document I have submitted in another tender, they have accepted this one. Even the LOI where they have been issued, matlab, in respect of the other, they have accepted. Now, only for rejecting this and giving the benefit to the matlab, others, matlab, this has been done. That is my
It has to be for the benefit of someone.
Now here also we see the difference is 11 crores, matlab, where the tender value is 44 crores. And my 27 low percentage has been, matlab, I have justified, they have accepted, and they have issued me the LOI in respect of another. Now they are quoting the L1 bidder and L2 bidder, they are quoting above, matlab, 4% above the tender value. I have quoted, matlab, 20% less. I have the justification to the, it's public interest, matlab, government money. And so far as, matlab, this similar, matlab, if they would have, matlab, stuck to these technicalities. Since I had challenged this with regard to the technical evaluation. Now, after inspecting some of the documents of the L1 beta, I see that there are some clauses they have not complied with, but then they have been sent through. Yes.
That's all.
Yes. Absolutely arbitrary, in wherever required, this clause, somewhere they are accepting, somewhere they are rejecting. The same person. Chief engineer is the same chairman for all the different tender committees. They are rejecting in someone, they are accepting in someone, according to their choice. And right from the beginning, as I have said, the earlier also they were not accepting by this work experience certificate. Ultimately, they were. Considering the difference of 11 crores, these are, even if it is comes to a finding that these are not the mandatory clauses as such, because the technical evaluation and the technical capacity and financial capacity are the main criteria. And so far as bid capacity, even these documents are accepted, then also it's something about 3,600 crores, where requirement is only 44 crores. So my capacity cannot be doubted of doing it, including the RAT justification of 11 crores, less than my workplace. My bid has.
Yes, Mr. Nayak.
Lordship has seen the minutes of the meeting at page 104 law.
Just tell me the reasons why his technical bid has been cancelled, rejected.
That is page, it starts from page 104 and the relevant portion is at page 105. Lordship, three grounds were there, Lordship. Serial number 105.
Where
Lordship, first ground, tenor in serial number 5. The bidder has shown documentary evidence of only one air compressor against requirement of two numbers of air compressor as per RFP. That is one. Bidder has not shown one of his committed works. In the existing commitment, as per clause number 4.2 of RFP, the bidder has become L1 for job number so and so on 24/12/2024 under PWD NH work assignment. This is the same department law, which is not shown in the existing commitment. This is the second ground. And the third ground is bidder has shown one project in B value of annexure 6, having contract value more than rupees 300 crore, having delay more than 3 months from scheduled completion period. However, the work has not been shown in annexure 8, details of ongoing projects. So this is the third ground, Lordship. So far as I'm coming to the main ground, Lordship, that is.
What about the first ground, this air compressor?
Yes. The Lordship, for that, Lordship will have to come to my affidavit at page 155, Lordship. This is paragraph number 6. Paragraph number 6, 155.
Yes.
The deponent begs to state that the tax invoice submitted by the petitioner at TAC 2 is 29.
Read 155, doesn't start like that.
If 155, it is the affidavit, Lordship. Serial number, paragraph number 6.
Affidavit or response number 2,
Yes, Lordship.
paragraph number
6.
6. That has been done. Look, that has been done.
Yes. The deponent begs to state that the tax invoice submitted by the petitioner at TAC 2.
Oh, you see, Mr. Naik, when you all start reading, please start from the
Big-
first word.
Yes, Lordship.
You all
That-
start from somewhere in the middle of the second, third line.
Second
So
line.
I have to start from, I have to start from the beginning.
That as regards
Yes,
As regards to the averments made in paragraph 8 of the incident petition, the deponent begs to state that the tax invoice submitted by the petitioner at TAC 2 clearly indicates the supply of only one set of air compressor at a total cost of rupees 1,65,000, excluding GST 18%. Further, the cost breakup provided by the petitioner in the clarification dated 5/4/2025 is neither reflected in the tax invoice nor in the sales certificate. Therefore, the claim that it comprises two air compressors is not at all acceptable. Moreover, the sales certificate mentions only about one chassis number, clearly indicating that purchase of a single air compressor. It is also important to note that there is no reference or indication that one set equates to two air compressors. Rather, it is understood that one set includes all unassembled components required for a single air compressor. Accordingly, this is treated as a lack of documentary evidence to support the claim for two sets of air compressors. So this is as a.
So, according to you, whether you call it a set or you call it an air compressor, a set of it means one air compressor and one air compressor simpliciter means one air. So both of them means one air.
Yes. But that is the first ground also. Then his representation, Lordship, it was also submitted after 7 days. Lordship, it comes to paragraph 7, Lordship.
Paragraph 7. Yes.
That as regards to the averments made in paragraph 9 of the incident petition, the deponent begs to state that regarding the representation dated 5/4/2025 submitted against the bidder M.K. Hatiboga, that is the other bidder, Lordship, for the work of performance so and so in the state of Assam under Dibrugarh NH division,
for the year 24-25 job number so and so, it is to state that the minutes of technical bid evaluation of PMBC job was uploaded on 23-2025 and financial bid opening was done on 27-3-2025 after granting 7 days time in the portal of objection, if any, for the bidder as per clause 23.5 of the RFP. However, the tenor MS Tenor Engineering has submitted representation only on 5-4-2025, which is 15 days after uploading of the minutes of the technical bid evaluation. Therefore, any such representation raised by bidder after 7 days of uploading the minutes of dated 17-3-2025 of technical bid evaluation cannot be entertained. That was in respect of that place, work lordship. Against which complaint was made that in this case, the same criteria was not followed. Because no objection was raised, lordship.
Which one, that item for the number 2?
In respect of one MK Hatiburua lordship, he raised one objection that in case of him,
After that air compressor.
other bidder lordship. Paragraph 8, lordship, that as regards to the averments made in paragraph 10 of the incident petition, the deponent begs to state that the petitioner was informed of the L1 status report of work raising of NH15 from channel 402.400 kilometer to channel 403.900 kilometer, total length of 1.500, along with providing with 3 numbers of box culvert in the state of Assam under annual plan of 2023-2024. EPC job number so and so by this office letter number so and so dated 24/12/2024. So it was informed to him not. And were asked to submit justification for its abnormally low and below quoted rate. In response to this office letter, the petitioner submitted its justification on quoted rate by letter number so and so dated 2/1/2025. The bid due date of the instant work was on 18/2/2025. And the petitioner has received intimation of L1 status for job number so and so, in view of which bidder's request has not been accepted, as the petitioner has not shown the said work in P value in his bid. Now, at this stage, lordship, if your lordship comes to that clause 4.2, lordship, at page 47, it starts from page 47, and the relevant portion is at page 48.
Yes.
Page 48, this is B, lordship, third line, B.
Yeah.
Lordship, this is
For the sake of
for the
clarity.
purpose of bid capacity, calculating the bid capacity of a particular tender. B value updated to the price level of the year indicated in the table at note 3 below of existing commitments. This work in that there is a separate format for showing existing commitment. Works for which the bidder has emerged as the winner of the bids or ongoing work to be completed during the period of completion of the work for which bid is invited. For the sake of clarification, it is mentioned that works for which bidder has emerged as winner. Winner has no specific term, lordship. If you have become the L1, then you are the winner of the bids, but LOA has not been issued as on the day before opening of the financial bid shall also be considered while calculating the bid value. So if you are L1, even if you have not been granted
Letter
the
of
LOA,
letter of
to
acceptance.
show that particular work.
So his case was that he was L1, but final selection had not been, no, but he had not been selected or something. What was his case? His case.
He has been declared L1. It was uploaded, lordship, in the official website. So he is aware.
He is aware.
He
But
was
then
communicated
he
also.
says that this is not applicable
But,
to him. Why?
but the rate was abnormally low. See, justification was
Because of the
softer.
justification.
So in any case,
Okay,
lordship, he
okay.
was L1. He was the winner.
Okay, because he had to make a justification.
Yes.
So he says that this is not applicable.
Lordship,
That's what he
today,
said.
lordship, what offense, lordship? Even if the rate is abnormally low, we cannot reject his tender on that ground.
Correct.
For which, lordship,
Unless
we
and
impose
until-
additional performance guarantee. That is the law now, lordship. Generally, it is not rejected. we impose additional performance security or performance guarantee, Lordship, and we allot the work to them only. So just because a justification was sought, his status as L1 has not changed. So he remained winner even prior to the last date of submission of bid, Lordship.
And that was with regard to this, no, some other.
Some other tender. Other tender.
Lordship, if I may. Just a minute, just a minute. One at a time.
Sorry. Continue.
Okay.
And so far as the third ground is concerned, Lordship, I am coming to page 158 of my affidavit, Lordship, paragraph 10.
Yes.
Paragraph 158.
Yes.
That as regards to the averments made in paragraph 12 of the instant writ petition, the deponent begs to state that as per appendix 1A, annexure 8 at page 63 of the RFP, but in this case, it is page 116, 116. Due to existing commitments. 113.
That is appendix 1A.
Appendix 1A, annexure 8. At page 63 of the RFP, in the event 113 Lordship.
Yes.
Two pages I am referring there. In the affidavit Lordship, it is 158. In the writ petition, it is 113.
Yes.
I am referring to this particular part.
Okay.
In the event that the bidder has failed to achieve the completion of any project within a period of 90 days from the scheduled completion date of the project, unless such failure had occurred due to force majeure or for reasons solely attributable to the authority, the bidder shall be deemed to be ineligible for bidding this project, both as the sole party or as one of the parties of joint venture consortium, if any, during the period from scheduled completion date to issuance of completion certificate for that project. This restriction is applicable if the contract value of the delayed project, was not less than 300 crore. The petitioner has to show the details of the project which has a contract value of more than 300 crores and having a delay more than 3 months from the scheduled completion period. The PEC has already accepted the project construction of two-lane road of 14 Pangin section of NH 13 from kilometer 163.50 to kilometer 206.66 in the state of Arunachal Pradesh under Arunachal Pradesh package of roads and highways of SARDP as any as eligible project as per the Honorable Guwahati High Court order number so and so dated 18/11/2024. Since the project having contract value of more than 300 crore has been delayed by more than 3 months, as mentioned by the bidder in B value of Annexure 6, the same is not shown in Annexure 8.
You see, but out here, he's only a subcontractor.
That who will clarify that?
Huh?
Who will clarify that? This is a project belonging to Arunachal government. Lordship, here he has shown this project just to enhance his bid capacity. But so far as if it is shown in the table of existing commitments, Lordship, it will lower his capacity. I have this many numbers of existing capacity. That indicates less bid capacity. So that is why he preferred not to show that work as bid capable as existing work, but.
No, but then, when you look at para 10, page 158,
Yes, no.
it does not indeed, it says only that the bidder shall be deemed to eligible for bidding this project, both as the sole party or as one of the parties of joint venture slash consortium. So, joint consortium, venture consortium not applicable because, and then he's not the principal, he's not the principal, contractor for that case. Where where he has done only 49% of the work.
Yes. But that breakup is not there. Lordship, it comes to page 111.
No.
Lordship, he is saying that 49%, but out of that 49%, Lordship, how much is pending or how much is completed, that cannot be ascertained from this table.
So that will be, that contract work was done where? Arunachal?
Yes.
So Arunachal PWD will have to
No.
can clarify this. And that has not been shown by the.
But our only question is that as it is shown in this table, that this many percentage of work are still to be completed, it has to be taken as an existing commitment.
Hasn't he shown somewhere that he's the
Page 113, Lordship.
he's the subcontractor, page
Page
113.
113. This is existing commitment made.
But then once he has completed, where is his commitment? But then that has to be clarified.
Yes, here Lordship, he has shown that percentage of balance work, Lordship. Lordship, this is column number 1, 2, 3, 4, 5, 6.
He is showing the prescribed form. That's why it has not been shown. There is a clause in the.
Let me see. Yes,
Coming to that.
That's why it is on the.
page.
Page 110. Lordship, may kindly see the heading of the column.
Yes.
Balance works. This is 1, 2, 3, 4, 5, 6, 7, 8. Column 8.
Yes.
Balance work. Balance value of work to be completed.
Yes.
Now, Lordship, comes to page 111.
Yes.
This 33.34 crore is balance work.
Yes.
Means it is existing commitment.
Huh.
Be it in the part of the, the subcontractor or the principal
1,
contractor.
2, 3, 4, 5. 1, 2, 3, 4, 5. 1, 2. This is the construction
Column
period.
8, Lordship.
Huh?
Column 8.
But then it says construction period.
Balance value of work to be completed.
Volume 7.
No, Lordship, it comes to page 110.
Yes, I mean. 1, 2, 3, 4, 5, 6, 7. So balance work is 301.
8, Lordship. Column 8.
Column 8
Balance value of work to be completed.
to be completed.
Serial number 8.
33.34.
33 point. Now, Lordship, whether this work, Lordship, value of work, balance in respect of the subcontractor or
the
of the
principal.
principal contractor, that cannot be ascertained from this table. So if balance work is there, it should have been shown in the existing commitment table. That has not been done. Moreover, Lordship, at page 68 of the petition, Lordship. (26.1) Lordship. Page 68 of the writ petition.
Yes.
Page 68, serial number 26.
Page 68. Yes.
26, Lordship, examination of bids and determination of responsibility. 26.1, During the detailed evaluation of technical bids, the employer will determine whether each bid A meets the eligibility criteria defined in clauses 3 and 4, and B contains the required documents as per format. Lordship will kindly take note this point, Lordship, format given in the RFP. And the documents uploaded by the bidder are in order, and C is substantially responsive to the requirements of the bidding documents. So it was not there, Lordship, that is why he has been declared technically non-responsive. So basically, these are the grounds, Lordship. And one representation he submitted, Lordship, if Lordship comes to page 199, Lordship. He submitted one representation, Lordship.
Page 199.
Yeah, of the
Yes.
on submitted on 5/4/2025, Lordship. And this is the response to the, from the department, Lordship, to his representation. Herein also, we have taken the grounds that has been taken in the affidavit, Lordship. It was rejected. Basically, this reply is the summary of my submission.
Well, you see, the issue of whether there be two air compressors and one air compressor can be seen physically. Why do you need the thing also?
Only on one ground this tender could have been rejected because of the non-disclosure of that work. Similar case.
Non-disclosure of that
pending work.
that pending work where he has completed his part.
That will change his bid value.
No, where he has said that he has completed
Yes.
that 49%.
Yes.
He became L1.
Achha, that's L1.
Yes. And while similar circumstances, earlier we have moved the person who is now L1. We moved the honorable court before the learned single judge, we lost. Division bench upheld it, and ultimately this matter went to the Supreme Court on similar ground. The Supreme Court upheld the order of the division bench. I have given your lordship that your lordship will kindly see the read appeal number 3624 that I have just given you. I'll just place two copies.
What is this? They were saying that you wanted to file an application for impleadment or something like that.
I am a caveator. I will not place anything on the facts, my learned friend. Your lordship will only refer to the judgment.
You're a caveator? What do you mean?
I was a caveator because I am now after the opening of the financial bid, I am the L1. Yes, that's right. Technically responsive. And
are you a party here?
No, they have not made us a party. So that's why. Well, I'll not place anything. Only this judgment your lordship will look only on the law point, because factually my learned friend has clarified. So your lordship will only see paragraph number 4.
Paragraph 4.
Paragraph 4. Your lordship got it. I'll just refer because my friend has presented the factual position. Prior to the evaluation of the paragraph 4.
Yes.
Prior to the evaluation of the technical bids of the above referred bidders, the appellant in read appeal number 36 of 2024 filed a complaint against the company and other, namely Messrs. M.K. Hatibura and Company, alleging that both of them had not disclosed about the ongoing work, and as such they had violated the condition mentioned in clause number 2.6.2 of the request for proposal bid document. The Technical Bid Evaluation Committee in its meeting held on 14/6/2023 evaluated the technical bids submitted by the bidders and declared the technical bid of 4 numbers of bidders, namely Messrs. Tapnan Dr. Kaushal Sharma, Hatibura and the company as non-responsive with bid. However, declared the bids submitted by N.K. Agarwala and Sanjay Kumar Singh, the appellant in read appeal number 36/24 as responsive. Now, if your lordship will kindly look, ultimately the observation, this was the facts.
No, who are these persons?
These are the persons who Sanjay Kumar Singh was the respondent in the writ petition. He was the L1. His bid was rejected. The petitioner's bid was rejected. L1 was not accepted.
You are actually L1 is now Sanjay Kumar Singh.
Yes, I am also now Sanjay Kumar Singh in this case. Now your lordship will see paragraph number 42 at internal page number 18. It starts from 37, 38, 39, and 40, but you'll also look at directly paragraph number 42.
Yes.
In the present case, the technical bid evaluation committee came to the conclusion that as per the condition mentioned in the bid documents, the company was required to disclose all the ongoing works, be it in the name of one of its director. We have the view that even if the said interpretation of the technical bid evaluation committee is not acceptable, then also that by itself would not be a reason for interpreting with the interpretation. That the various judgments of the Honorable Supreme Court has been referred in regard to tender document. Then your lordship will kindly see paragraph number 45.
Yes.
The learned single judge, while interfering with the decision of the technical bid evaluation committee, has observed that the financial bid of the company is significantly less than that of the appellant Sanjay Kumar Singh, and therefore element of public interest is also involved, and this subject is also relevant and cannot be overlooked. In this regard, the judgment has been referred. Then ultimately the finding of the court is at paragraph number 49. In view of the above discussion, we are of the view that the improved judgment passed by the learned single judge cannot be sustained. Then the matter went to the Honorable Supreme Court. I have given the
You're
SLP
not
order.
given the, what is the ratio?
But ratio is that you have to disclose all the ongoing works and all in the prescribed format. That's the sum and substance. And admittedly, it has been not been disclosed in the prescribed format. The other laws by which
You have not said anything.
then your lordship has to read the entire facts.
Forget the facts.
In that case also, Lordship 4.2 clause 4.2 was there. In terms of that clause, Lordship, he was to disclose the existing commitments even in those.
Even if he's a subcontractor.
No, even in those cases where he has, although no LOA has been
Yes.
issued, he was declared as the
L1.
Yes.
But where he was required to justify the rate. No,
justified to be.
no, that issue is not there.
But
out there, so there is a difference between this judgment and his judgment.
So far as this judgment is concerned, Lordship, in this case, Lordship is the second ground.
That's so the first ground is whether the two air compressors whether they're two air compressors in one set.
The basis of documents submitted by the petitioner, it can be
Said,
inferred that actually it was a
two air compressors.
bid for two companies.
that they will do, my lord, I cannot say.
That I have already explained.
That they have explained.
That it cannot be a second.
Now, number two is whether the
Whether the work in which he was declared L1.
L1
was required to be disclosed or not.
was required to be disclosed.
That is the all about this.
Correct. He says that because he has to still make justification, he cannot be considered to be the winner.
That is
That is his
but
speech.
similar justification was given in this.
Because LOA,
Yeah, where?
I have to. Just, just a moment. Paragraph number 16, your lordship will first see, which talks about non-disclosure of the work.
Yeah. I am not on non-disclosure. I am on the
Yes.
issue of
The
whether
disclaimer.
just because the L1 needs to justify his rate. Does it take away the fact that he is the winner or the L1?
But in this case also, what I remember, I'll taking out one, the work, the person who was, who did not succeed, his LOI was issued on March, and ultimately the last date of the tender was somewhere in May. I'll come to that paragraph.
Mr. Counsel,
Yes.
let us not, you see, the question raised by this court is very simple.
Yes, ma'am.
He is L1
Yes.
in one contract.
Yes.
But he has been asked to justify his rate. According to you, even if he's been asked to justify his rate, he still remains L1.
Yes.
And accordingly, he still remains, he is to be considered as the winner of that.
No, it has to be disclosed.
What has to be disclosed?
Once he is a L1, he has to disclose.
Yes, to disclose that work for the purpose of
Calculation of the bid
capacity.
capacity.
He has to disclose.
Yes.
So what I'm saying is that he, according to him, he doesn't have to disclose because justification is still required for him, and as such, it cannot be said that he's the winner. That's what he's saying.
That is it.
That is his saying. So now, so there is no citation in either of your favor. No citation.
Lordship, in that situation, whether Lordship will go through the strict interpretation of that clause or his justification not to will.
That is, I think, your interpretation will have to be probably taken into consideration.
Quite clear now.
4.2.
4.2. I'm once again submitting of page 48.
Anyway, everything is still a muddle now.
But
I've got I think I'm getting a certain,
But so far this case is
the gist of the case, huh?
So far this case with the earlier judgment, there was no question of seeking justification. Now he is trying to give an interpretation which is
Correct.
against since justification.
That is his job.
So, but your lordship knows the power of the technical bid evaluation committee to consider how to interpret the tender documents. But I will not comment on it. And price, so far he has taken that it is 11 crores, and that has no significance because it has.
I will not go into all those issues. I'll just go into those 3 issues.
Yes.
It is not that I did not disclose. I did not mention in annexure 6.
In the prescribed format.
But I mentioned, I have given an undertaking.
No, with regard to number 2.
Yes, LOA. Disclosure is there, but not in the format. I have given separately by an undertaking that is a part of the technical bid. Page 125.
No, anyways, just let me start.
So it is not that I did not disclose, but then I did not mention because I am not very sure whether I'll be winner or not because they have not accepted my justification.
Well, now we will have to decide. Now let me decide.
Yes.
We cannot go by whether you are unsure or not sure or what.
Yes.
Let me decide whether it's correct or not.
Yes.
And if you find that I'm incorrect, either one can go, and challenge that.
But so far we are concerned in the earlier case, there was no question of justification. It was the.
Mr. Counsel, I cannot hear you. You can please sit down because we are not a party here.
No, I'm only submitting on the law point, nothing more than that.
You cannot even submit on the law point. I will ask you for a submission. Right.
One further aspect, my lord, in the affidavit perhaps they are.
No.
They are saying 2 set. They are saying 2 set.
They said 2.
2. Well, in the affidavit page.
See, I am not going by the affidavit.
155. No, their ground of rejection is that I did not submit 2 sets. 155.
Look, I just want, the issue of whether it's 2 or 2 sets, I do not know. That'll have to be, they are the ones who are authors of the tender. They'll be the best persons who can interpret their needs and how the contents of the tender conditions have to be interpreted.
Exactly. But then it cannot be, may not be arbitrary. In one case.
Cannot be arbitrary, but then.
In one case you accept 1 set, in the other case you.
I do not know, but one thing I'm very sure. 1 is not equal to 2. That document that you are showing me is only with regard to 1 air compressor. That is not equal to 2.
And also he's been accepted.
Maybe a wrong does not, just because the wrong has been committed earlier, does not mean that it has to be perpetuated for all future transactions.
No one is saying wrong that he has been given L1.
Look, no right accrues to a person just because the wrong has been committed by somebody.
That is there. That is there. But these are not mandatory condition. These are just directory.
I don't know. I am the issue whether it is essential condition or ancillary. That also has to be left to the wisdom of the authorities, not the wisdom of you and me. It is the money is going to be spent by them, their own money.
Yeah.
Who are we to say that it should be interpreted this way?
The different treatment, why am I in the affidavit in reply also I have said, so far as he is deficient of certain.
That is the power that they have. That's the power that they have. Yes. Our role in contract matters is very, very small. You know it better than me also. Right.
Not just foreground on the standard. Just what if these conditions are all, mandatory conditions. I'm not elaborating, just submission are mandatory conditions. Secondly, lot of no public, it's a contractual matter, no public interest. rather it is in our favor, because it's a road project. Totally.
No, his case is that it is in public interest because 11 crores are going to be saved by you.
That has been done by this.
I know. Anyway,
That I have paid.
please, Mr. Kumar, you can please sit down that side. You are not even entitled to say anything right now. If we allow this type of advocacy, then each and every one of the councils here can interject in each and everyone's case.
I take back everything, but silence is the best discussion in
Yes,
some cases.
yes, and especially after I've
Yes,
given you a
yes.
chance to speak.
There cannot be no velocity. Arbitrariness cannot be there because reasons have been given in the bylaws itself. Lordship may consider it. And fourthly, Lordship being the author of the tender, Lordship, and the basis of the interpretation. And for that purpose, last time, like,
Okay, let me see if I can do justice to what you have said. So it's still swirling around in my head. Anyway, right. Heard Mr. P.J. Saikia, London Senior Counsel for the petitioner, assisted by Mr. P.J. Saikia. Any relation? Your son?
Yes.
Oh, okay. Okay. So all in the family. Okay, right. Also heard Mr. P. Nayak, learned additional AG for the state of Assam, and Mr. No one else. You're a caveator,
And we have also filed an application for.
but you're not a party here.
No, we have also filed an application for implement on 25th of April.
Okay, then what happened? Then why didn't you press that?
I submitted at the beginning whether he wants to press that. He said he don't want to press that.
No, it did not come on record on that particular.
Okay, it's not
also
listed
happened
today. Oh, okay. Then you could have mentioned in the morning, we could have called for it. You could have called for it and then you could have made another half an hour of submissions also. But unfortunately, what to do? His application is there. You call for his application, we put him since he's there. We call for it. If it is not under objections, we'll allow it. Because he's L1. Production is better than this. Right, heard Mr. So as we'll, okay, then heard Mr. Quad Learned Counsel for the respondent number. He'll be respondent number 5. Of course, if it doesn't come in time and we don't make the odd thing, then I'm going to throw your name out. Okay, because unless you're impeded, you cannot. Right. The petitioner is aggrieved by the rejection of his technical bid in relation to the NIT dated 18/1/2025 issued by the respondent number 2. For, when is that NIT?
NIT as page 34.
30?
34.
Acha, for this, okay. It is here, in this order also it is here, 10/4/2025. Huh? For performance-based maintenance contract, so, 25/277. Okay, till there. Pusta. The petitioner is agreed with. The petitioner's counsel submits that the petitioner's technical bid had been rejected on the following ground. Number 1, the bidder had shown documentary evidence of only one air compressor, against requirement of 2 numbers of air compressor as per RFP. What is RFP?
Request for proposal.
Request for proposal, bracket RFP. Number 2, the bidder has not shown one of his committed works in the existing commitment as per clause 4.2 of the RFP. First stop, the bidder had become L1 for job number 15/AS/2023/24/249 on 24/12/2024 under PWD bracket NH bracket NH works bracket close comma SM, which was not shown in the existing commitment. Number 3, the bidder was shown as having one project in B value of annexure Roman 6, having contract value of more than 300 crores, with a delay of more than 3 months from the scheduled completion period. For completion date. However, the work was not shown in annexure 8 bracket details of ongoing works bracket 2. Thus, the bidder was declared technically non-responsive in terms of clause 4.1 bracket J, small j, bracket 1, comma 4.2 of the RFP, and as per appendix -1 capital A and annexure Roman 8 capital of the RFP. Next paragraph. The petitioner's counsel submits that in terms of the list of equipments required of a tenderer, comma, the tenderer had to have 2 air compressors as reflected in section -2 appendix to ITB at clause 1. At clause 1.1 at clause 1.1 bracket 8, which is at page 78 of the writ petition. The petitioner, on the other hand, had submitted a tax invoice dated 20/10/24, which described the goods as Royal Model R1 gap 120 bracket trolley mounting air compressor ASSY bracket close. And the quantity was shown to be one set. This can be easily asked from the authorities here, whether one set means two air compressors.
Fine. That's very fine.
Right.
Just between that state and
Anyway, the and a sales certificate dated 20/10/24. The one earlier one was issued by Royal Industries, and a sales certificate issued by Royal Industries showing that a tractor mounted compressor R120 had been delivered on 20/10/24 to the petitioner. The petitioner's counsel submits that the tax invoice having clearly showed that one set of air compressor having been bought by the petitioner. The set included not only the trolley mounting air compressor, but also the tractor mounted air compressor. He thus submits that the petitioner had given proof of the fact that the petitioner had two air compressors for the contract work he had applied for. Next paragraph. The petitioner's counsel submits that who is that person, that person with the tractor? That
MK Hatiburu.
where is that? 115.
115.
Is it? Submits that one MK Hati Barwa and company had also had submitted a tax invoice dated 2/11/2019 to the state respondent authorities, to the state respondent, wherein, in respect of a similar work, wherein it showed that MK Hati Barwa and company had one air compressor, one piece of air compressor trolley type. So he submits.
Machine set.
One piece.
Machine set.
How does it set? It says one piece out here.
Air compressor, trolley type compressor, machine set. quantity one piece.
Okay. Machine set, so what do you mean? So it means these are two air compressors or what? Huh?
According to my instruction, they have said that.
Okay. What have I said? Trolley type. Bracket compressor machine set. Bracket 2. Full stop. As the equipment of MK Hati Barwa and company had been accepted by the authority, there was no reason to reject the petitioner's technical bid. On the ground that the petitioner did not have two air compressors. Correct?
We
Next
have
up.
submitted all this clarification by way of a representation. That has been rejected.
No, anyway. Basically, that's the basic thing. Next. First up, okay. He accordingly submits that the rejection of the petitioner's representation clarified the fact that the petitioner had the required two air compressors was arbitrary and had to be set aside. Next. Okay. Heard Mr. B.D. Kawar, learned, this is the IA. Heard Mr. B.D. Kawar, learned counsel for the applicant who submits that the applicant is L1 in the
After opening of the financial.
in the L1 after opening of the financial bill pertaining to the present case. And unless the applicant is made a party respondent, the final decision in the writ petition could prejudice the applicant if he is not heard. Mr. P.J. Saike appearing for the writ petitioner objects, some does not object to the application made by the applicant. Accordingly, the applicant is made respondent number 5. Is implemented as respondent number 5. Applicant shall submit a corrected copy of the cost title to the registry within 2 days. That means by tomorrow.
By tomorrow.
Within 2 days. I is accordingly allowed and disposed of. Then in the main case, you write in the first before. Then after so heard so, you write in view of the order dated 1/5/2024, 2025, passed in IAC 1394 of 2025. The Sanjay Kumar Singh has been included as respondent number 5. That's all. Okay. Okay, where are we now? Had to be set aside. Next. The issue, the second ground, the petitioner's counsel submits that the second ground for rejecting the petitioner's technical bids pertains to the petitioner not showing his committed work in the where is that under which
Lecture 6.
page?
Lecture 6, madam. Page 108.
108.
Yes, madam. And my It is the RFP, mine is 110.
Huh?
110.
Not showing his committed work in
108 is as per the format.
in the format provided
Just
for all existing commitments and ongoing work to be completed during the next 1 year. Pushpa. In terms of clause 4.2 of the RFP. The petitioner's counsel submits that though the petitioner had become L1 for job number 15/AS/2023/24/249 on 24/12/2024 under the PWD bracket NH Works Assam. And though clause 4.2, where is that? Page 4.2? Clause 4.2?
47.
Huh?
47.
Page?
47.
Though clause 4.2
relevant 48.
required the winner of the bids or ongoing work to be completed the required the winner of the bids, but who had not been issued an letter of acceptance by the authority to show the same in the format provided for in the format provided under Annexure 6 under Annexure 6 of Appendix 1 capital A. The petitioner had not done the same due to the fact that the petitioner's bid amount was
27.04% below.
27.04% below the estimated amount. As the state PWD had required the petitioner to justify his abnormally low rate
Letter dated
slash bid by letter dated
24 December 24.
24/12/2024. The petitioner could not be said to be the winner
I have submitted my justification. Nothing was heard there.
of the bid slash tender. Inasmuch as the justification for the low rate provided by the petitioner has not been decided by the state PWD till date.
No, they have decided subsequent to the
Had not decided had not decided the same.
Justification till due date of the bid.
Huh?
They have not decided the
They
justification.
have not decided the justification prior to the last date of submission of the bids. pertaining to the present NIT dated 18/1/2025. Comma, though the justification has now been decided after the last date of submission of the bids, that is on 21/2/2025. Next. No, full stop. He just submits that there has no, that he just submits that the rejection of the petition's technical bid on the second ground is also arbitrary, injure the real schedule. Next. The petitioner's counsel submits that the rejection of the petitioner's, the submits that the third reason given by the state respondent for rejection of the petitioner's technical bid is on the ground that the petitioner had not shown had not given information in Annexure 6.
No, has given information in Annexure 6, but not given information in.
Oh, yeah, has not given information in Annexure 8. Comma, though it had given information in Annexure 6 with regard to the fact that in a contract worth more than rupees 300 crores, comma, the contract work had not been completed. Full stop. The petitioner's counsel submits that the said contract work pertain to
Subcontract of a road
oh,
project.
no, what is the contract work pertain to?
Road
Where-
project.
Where is that? Page? Huh? 1-1? 1-1-1.
Yes.
Pertain,
Serial number 8.
pertain to the construction of two-lane road of 14 POTIN dash Pangin, PANGIN, section of NH 13 from KM 163.50 to KM 206.66, bracket package dash 5, bracket close, in the state of Arunachal Pradesh, under Arunachal Pradesh package of roads and highways of SARDP-NE at a total estimated amount, at a total estimated amount of rupees
301.644.
334.98.
Yes.
The said the balance value of the work to be completed was 33.34 crore, comma, in as much as 301.64 crores work had been completed. The petitioner's counsel submits that the petitioner was a subcontractor for the said contract work, wherein the principal contractor was whom?
Rose Dine.
Huh?
Rose Dine. What you will find in name at page 128.
Was
Messrs. Joint Stock Company Industrial Association.
just a minute, was MS Joint Stock Company Industrial Association VOZ ROZ HDENIE. Sounds like a Russian name.
It's
Can't
a
pronounce it.
It's a Russian company.
Huh? Russian name?
Russian.
Oh. Ah, full stop. He submits that the petitioner's subcontract work worth 49% of the total contract cost, total estimated cost, has been completed by the petitioner prior to, no, when was it completed?
30th November 2023.
Was completed on 30th, 2023,
And amount is 1641.
amounting to rupees
164141 8631.
164141
8631.
8631. Okay.
164 crores.
He submits that the balance work of 33.3 crore has to be completed by the principal contractor and has nothing to do with the subcontractor, who is the petitioner. He accordingly submits that as there was no liability on the part of the petitioner with regard to the remaining part of the unfinished contract work, which has to be done by the principal contractor, the petitioner was not required to make a disclosure of the same in Annexure 8 of the RFP, is it? Of the RFP.
Appendix 1A.
Annexure 8 of Appendix 1A of the RFP, of the RFP. Accordingly submits that when there has been a justification of all the three reasons for disqualifying the petitioner's technical bid, the respondents could not have stuck to their decision to disqualify the petitioner. Disqualify the petitioner's technical bid. That's all. Any citation? No.
Well, they had also the option of seeking clarification if required under clause 23.4.
He also submits that though the respondents had the option to clarify the issues in terms of clause 23.4 of the RFP, the state respondents have not sought to do the same. Next para. Mr. P. Nayak, the learned additional legi Assam submits that submits with
Paragraph 6, Lordship, for the first ground of.
yes, page 155, no? Submits that the tax invoice submitted by the petitioner clearly indicated that there had been a supply of only one set of air compressor at a cost of rupees 1,65,000, 1,65,000, excluding GST. Was the further the cost breakup provided by the petitioner in the clarification dated 5/4/2025 was neither reflected in the tax invoice nor in the sales certificate. Therefore, the claim of the petitioner that the tax invoice comprised of two air compressors was not accepted. Moreover, the sales certificate mentioned only one chassis number, clearly indicating the purchase of a single air compressor and not two air compressors. Those are- Next para. The learner additional age further submits that.
Seven and eight for the second.
Submits them. Regarding the representation dated so and so, you take it from page 156, from here to here, okay, 156. And then
Eight.
para 8, for what, which part?
For second. That. That and one.
And para 8 also. So instead of para 8, you just write this next para. Mr. P. Nayak also submit that the petitioner was informed of his L1 status for the raising of NH 15 from census. Okay, yeah. No problem. There's too many numbers out here. Right census. Okay, page 8. Okay, 8 also. Then we continue. After that, he submits that just because the petitioner has been asked to submit his justification for his abnormally low rates, the same did not imply that, no, did not mean that the petitioner was not the winner of the contract work, inasmuch as tenderers who have submitted abnormally low rates have been asked to do the contract work after after imposing additional performance costs, performance guarantee, performance guarantee slash security, performance security upon the for doing the contract work on the basis of abnormally low rates. And what is the next?
Take note the paragraph 10.
With regard to the petitioner, next para, with regard to the petitioner's technical bit being rejected on the third ground, the learned AG submits that para 10, it is from here. Submits that from here, with the rubber, no rubber. The petitioner has to show the details of the project which has a contract value of more than 300 crores and which had been delayed for more than 3 months from the scheduled completion date period. Though the petitioner has taken a stand that he had completed his part of the contract work as a subcontractor, that is 49% of the total contract work. There is nothing to show or prove that the petitioner had completed 49% of his portion of the contract. As has been delegated to him by the principal contractor. The learned addition AG submits that there is nothing to show that the remaining balance work to be completed amounting to rupees 33.34 crore out of the total estimated amount of 334.98 crore is the uncompleted work to be done by the principal contractor or the petitioner as a subcontractor. He submits that as the said clarification has not been made. Has not been, as the said distinction, as the said issue had not been clarified by the petitioner at the time of submission of his bid documents, comma. The state respondents, there was no infirmity with the state respondents holding that the petitioner had not completed his work within the stipulated completion date and as such had violated the terms of the had violated the terms and conditions of the RFP by not disclosing the same in annexure 8.
Appendix 1A, annexure.
In appendix 1A, annexure 8.
One more ground gets taken on, that is clarification under as per clause 23.
Yes, yes.
Okay, in my TPP, I have taken that no clarifications were sought for as the discrepancies were slow grading. That was the reason.
No discrepancies was sought for. No clarification was sought for.
Yes, no clarification was sought for as the discrepancies. I mean, reflected in the bid law, was grading and overwhelmed. It was a clarification.
He did not seek any clarification.
No.
No, you did not seek any clarification. Okay, right. The Mr. P. Nayak, the additional AG submits that no clarification was required to be made in respect of the
Grounds.
grounds of rejection of the petitioner's technical bid under clause 23 point. Where is this 23.6? Let me see which page is it?
23.6, my lord, 67.
23.4.
Subparagraph.
Inasmuch as the reasons, inasmuch as the grounds were glaring and did not require clarification. So stop. Further, the clarification of a bid by an employer is the personal discretion of the respondent authorities in terms of the said clause. That's all. Then, Acha, the non-AG submits that in view of the petitioner not having complied with the essential conditions of the contract, there was no infirmity in the rejection of the petitioner's technical. Next, Mr. BD Over, London Senior Counsel. Submit, anything to submit?
But these are first is my lord, that it is an admitted fact that they have not submitted it in the prescribed format. Second, my lord, your lordship knows that the authority who authors the tender document, they are the best person to judge. So I will not comment on it. Secondly, my lord, the interpretation which my learned friend is trying to give before this honorable court, that is not acceptable because ultimately it is the expert committee which have decided that it has that the tender document is not in order. And my lord, so far price is concerned, he has taken on ground of price. Price may not be always the consideration in determining that tender here, because ultimately sometimes the quality of the work and all these factors has to be taken into consideration.
That's one thing you're right. The petitioner's counsel also submits that the petitioner's quoted rate is less than the rate quoted by the respondent number 5 by more than 11 crore. And as such, it would be in public interest. And as such, the writ petition have raised the question of public interest. Then Mr. B.D. Kwan, Senior Counsel for the respondent number 5, submits that it is settled law that the author of a tender is the best person to know its needs and is the best interpreter of the terms and conditions of a tender it has authored. What else? That's all.
Page 68, that it has to be in the prescribed format.
What has to be in the prescribed form?
On clause 26. Page 66, my friend has referred.
Page 66.
68.
Yes.
During 26.1, during the detailed evaluation of technical bids, the employer will determine whether each bid B contains the required documents as per format given in RFP, that is request for proposal, and the documents uploaded by the bidder in order. Here, admittedly, it is not in order. And as per format.
I think we'll fix this. We'll give you a small chance. Let him say it through them.
That's enough. I'll not say it.
No more. Let's say Mr. B.D. Cover also refers to clause 26 of the RFP to show that there has been what? To show that there has been
admittedly the
detailed consideration of the technical bits of the tenderers at the technical bid evaluation stage and the interpretation of the respondents with regard to questions of fact would have to be accepted by the fact.
Well, one short submission from his, as per the tender condition, if the materials has to be accompanied by the fitness certificate. Both the L1 and L2, the machineries they have submitted, it is not accompanied by fitness.
You have no challenges selection.
That has not come because this financial video open only while pendency of this petition.
So unless you have a challenge, how can we go into those issues?
But to show that they are for different yardstick has been applied so far as me and the respondent number 5 is concerned.
That you file a separate.
Beyond the pleadings.
That's separate.
He is submitting for
He's only submitting on the law and what is there in the thing. He's not going beyond the facts.
I'm also so that I'm not
You are going into facts.
Relying on the Tata Motors to show that arbitrariness, how they are the different yardstick they have been.
That, you see, first you have to overcome your rejection of your technical bid to make a challenge to his selection.
Right.
Because Tata Motors doesn't help you. Tata Motors, in fact, helps him for the time being, Unless only once if this court holds that yes, the rejection of your technical bid is wrong or illegal, then only you have a right to challenge this. Otherwise,
First part arbitrary.
as for Ronak, it is said that it will be misplaced to allow you to challenge a selected
Only to the extent
tender.
of arbitrariness. For him, it is fine. For me, it is not good. Unless.
Hearing of today's judgment is good.
Unless.
We are blessed.
But let me hear. What is this matter?
Tender, actually they were settled.
Oh, you have adjourned them. What is
Now,
this? Item
initially,
15.
well, I just place the facts on that. Initially, they have settled two vehicle get without tenders. Subsequently, this was interfered with by this honorable court. That your lordship will get it at page 25.
No, okay. No, you see,
Now-
there were two vehicle gates. You
Two
are now interested in which vehicle gate?
Detox channel.
Okay. So it
Tender was
had been
open.
settled with somebody that was interfered with,
Yes.
and then thereafter issued a NIT,
Notice, yes.
and now they have cancelled that and issued another NIT.
Yes, not even formally, no cancellation order is there. After opening of the tender, bids, etc., my lord, they have issued another.
And that without
Shortly.
cancelling the earlier NIT.
Yes, and also, my lord, we have opened our bids.
Bids have been
We
opened.
have opened. There are two judgments, my lord, I am relying.
No. Yes.
No, Lordship, because as I have already submitted for your Lordship today morning, after my submission, I have received the copy. After
Okay.
receiving the copy, I have.
He said in the morning he didn't receive a copy of the petition.
After
We have
receiving,
given, my lord, them. Thereafter also we have given.
yes,
we have
So,
today morning I have received.
okay, so what is your case now?
Lordship, as per my instructions, telephonic instructions, which I have received since today is a holiday. So
During the holiday?
first,
You're having holiday there?
every state holiday,
Huh?
including the state offices, except our High Court, all others.
Acha. Mizoram also, High Court in Aizawl, they are having a holiday on 7th May.
We are
They are because of this panchayat election. Out there they are having because of Rabindranath Tagore's birthday, something like that. While the government is not having a holiday, High Court is having a holiday.
So
Anyway.
as per my instructions, Lordship, after this, before issuing of the second NIT, first NIT was cancelled and notices were issued. That is Annexure 4. My learned senior colleague is relying on Annexure 4 and Annexure 6. Annexure 6 is the new NIT and Annexure 4 was the old one.
Why was Annexure 4 cancelled?
Yes, that has been cancelled and
Why?
due to low price. The low estimate, the amount was low, that's why. Means during
To
the,
make a better, yeah.
during the midtime, when the council was running, when the authorities of the.
Will kindly see that
During the time when the council authorities were running the sec gates of these two gates, they have come to know that the amount which are being collected through these gates were quite high than the actual amount of settlement. That is why council authorities have decided to cancel this one, because if your lordship sees the earlier gate, it was 75 lakhs. Now the estimated amount was 1 crore, that is Annexure 6. Annexure 4 is the 75 lakhs.
Petitioner has quoted 1 crore 43 lakhs. Was there?
That is the lowest, that is the price low. That's why council authorities have decided to
change the condition of the contract.
No. There's not a question of change. If they want a better price, what is wrong?
Better price, well, first your lordship will kindly see when the first tender was issued in respect to the two vehicles. Your lordship will kindly see page 27. 27. This is in respect of two gates in the middle, 1 and 2. Mandar Disha vehicle gate 75 lakhs 37,000 and Detoxara vehicle gate 75 lakhs. the Lordship has seen, my lord. Page 27.
27 is the tender notice.
Yes,
Acha,
tender
okay,
notice.
so,
And the valuation is this, my lord.
okay.
First is Mandadesa vehicle gate, 75 lakhs 37,500, and Ditokchara vehicle gate.
So this is the
75.
government rate, this
Now,
is the government valuation.
Mandadesa, they have not done anything. But in respect of the Ditokchara, because in Ditokchara, my lord, 5 tenders were found to be invalid. And probably there people did not come. So therefore, they are issuing the second tender notice, my lord, and quoting, my lord, 1 crore. Now 1 crore 43 lakhs the petitioner has quoted. Earlier they have given the same gate, they have given it without tender at 1 crore. So therefore, my lord, and 5 tenders were rejected. Maybe there people are not there. So now this they cannot do it after
So you bring the record. You bring the record. You bring the heard Mr. B.D. Das, then senior counsel for the petitioner, who submits that pursuant to an order dated 24/3/2025, passed in WPC number, which one is the deduction?
Ditokchara.
Only one gate. This one is
Now
Ditokchara.
only one gate, the other gate they have not.
What is the case?
Ditokchara vehicle check.
No, in the earlier case.
Other-
There
other
was a
one.
case.
Earlier one.
There were two
Yes.
cases, there were two cases. But
127.
pursuant to the order
WPC
dated
1227,
24/3/2025, passed in WPC 127 of 2025,
Yeah.
the respondents were directed to issue a fresh NIT to make settlement, for settlement of the Ditokchara vehicle entry gate. Full stop. Pursuant to the order dated 24/3/2025, passed in 127 of 2025, the respondents issued tender notice dated 26/3/2025 at 2015, wherein the government reserve price for the Ditokchara vehicle gate was fixed at rupees 75 lakh. The petitioner and a few other tenderers submitted their bids. Huh?
10 bidders.
And 9 other bidders submitted their bid. Next, the petitioner's grievance in this writ petition is that without cancelling the tender notice dated 26/3/2015, the state respondents have issued a fresh short tender notice dated 22/4/2025 for settlement of the Ditokchara. So,
After opening of the price.
whatever. After opening of the price bid, wherein they have fixed the government valuation of the same at rupees 1 crore. 1 crore. Is it?
My lord, that is the second short tender notice. When in the first, my lord, first tender notice, they have opened it, and after opening.
Mr. Counsel, the question is, in the short tender notice, what is the government rate fix? What is the reserve price?
75. No, first one.
No, I'm talking about the second.
Second one is 1 crore.
That's what I'm saying. Is one crore. Next para. The petitioner's counsel submits that as the petitioner's bid amount pursuant to the earlier tender notice dated 26/3/2015 was 1 crore
43 lakhs 90 rupees.
43 lakhs 90 rupees, there was no justification for the state respondents to have issued the second short tender notice dated 22/4/2025, making the government reservation price at rupees 1 crore. You want 1 crore, he's giving 1.4.
No, the reserve price is 1 crore. We are getting more than 1, means more than 2 crores. That is what.
What do you mean? The reserve price is 1 crore. That means you are happy with 1 crore. Unless you make the reserve price 2 crore, there's no question of you dismissing, I mean, throwing away issuing the second tender notice. How can you issue the second tender notice?
Lordship, I have to take the instruction. I will bring it the record on Monday, Lordship.
Okay, right.
Let me place the record.
Mr.
RM Das.
R.M. Das, the counsel appearing for the
All the response.
all the respondents, submits that he will bring the records by the next day.
Yeah.
List the matter on
Monday.
Huh?
Monday.
Monday. Monday too many. Tuesday also quite a bit. But Tuesday. List the matter on Tuesday.
Let it be Wednesday, Lordship.
Wednesday is a panchayat. I'm going to give, you're not going to give vote. I'm going to give.
Oh, sorry, right. Then Thursday, Lordship, because Tuesday I will be not available.
Let it be on 9th, Monday. 8-1 matter is fixed.
Nine. I don't know. Friday I might not be. I might have problem.
Any other day.
Any other day, Lordship.
Okay, any.
13.
13th.
Huh? Is the matter on 13th? On which date the Ms. Saranda should produce the records? In the meantime, the short tender notice dated 22/4/2025, issued on 25/4/2025, shall be kept in evidence.
Issued on 25.
25. Right. Yes.
Well, that's the matter where.
I know. No privity of contract.
Lordship, the thing is that one of the vital aspect that my learned friend has missed is that Lordship, I am an MSN.
Maybe, but then you may be MSME, so what?
Yes, Lordship, there is a judgment.
But you've got to have a privity of contract, some contract with the respondent here.
No,
You've got
Lordship.
nothing.
I would like to present a judgment, a writ appeal, decided by this honorable, that's of this honorable court, Lordship. Same case, Lordship, same facts.
Okay.
Basically similar facts. So I am just going through the important paragraph that I'm relying on, Lordship. Writ appeal 330 of 2020.
Yes.
Yes, Lordship. On page 9, Lordship. I'm just going to the relevant portion.
Page 9.
Page 9, paragraph
Yes.
20.
Yes.
Paragraph 20.
Paragraph
21, sorry, Lordship.
21.
Yes.
Yes.
Having held as above, we are also conscious of the fact that the subcontractor Messrs. Girin Decca is a proprietorship firm registered under micro, small and medium enterprises.
Yes, I mean, yes. Since you are already here, another 5 minutes is finished. No, it cannot take too much time. They are all tired. In fact, I've got judgments to dictate also. Yes.
Yes. Having held as above, we are also conscious of the fact that the subcontractor Messrs. Girin Decca is a proprietorship firm registered under the Micro, Small and Medium Enterprises Development Act 2006. Herein referred to as the Act of 2006 has been enacted by the Parliament for the purpose of facilitating promotion, development, and enhancing the competitiveness of micro, small, and medium enterprises, and for matters connected therewith or incidental thereto. From the object clause of the Act 2006, it is apparent that the object of the Act of 2006 is to protect and promote the interest of the micro, small, and medium enterprises. Then, Lordship, next paragraph, section 22D, the Act of 2006 defines buyer, which read as follows. Buyer means whoever buys any goods or receives any service from a supplier for consideration. Then, Lordship, the next paragraphs, 23, there is no dispute about the fact that the subcontractor comes within the meaning of definition of supplier as provided in section 2N of the Act.
A careful analysis of the admitted facts of this case, in our opinion, prima facie establishes a buyer-supply relationship between the appellant number one, NHIDCL, and the subcontractor falling within the scope of the ambit of Act of 2006. Lordship, and in this case, Lordship, this NHIDCL is in the same position as Power Grid was. Power Grid.
We don't know. I don't know. You'll have to show me that.
Yes, Lordship.
How you cannot just pick out one sentence here and there without
I'm
showing
just
the
explaining
connection.
the facts of the matter in.
No, you see, it's like this.
Lordship.
In this case,
Lordship.
Power Grid Corporation has given the work to that Necon. Necon has 5-6 subcontractors.
Lordship.
One of them being you.
That's one.
Now, your payment is paid through Necon, and in 2 or 3 occasions, the Power Grid has paid directly to you on the basis of the request made by Necon to pay to you.
Yes, Lord.
Okay. Now, so basically, right as on date, there is no agreement between you and Power Grid.
Lord.
Your only agreement is with Necon.
Yes, Lord.
So where is the privity of contract between you and them? And secondly, you see, when you have not made Necon a party also in this dispute.
But Lordship, in this case, Lordship, Power Grid steps into the shoes of Necon, Lordship.
How?
Because Lordship, Power Grid has made direct payments to me.
On the request of Necon,
Lordship.
was only on. You see, in this case, can you show me any document which says that Necon has to pay to you? Has direct asked them to pay to you? Not one. Those earlier payments have been made because Necon has asked them to pay to you.
Yes, Lordship, that is the thing, Lordship. But the thing here is that Power Grid has availed our services, Lordship. They have taken our goods.
Power Grid has availed the
Lordship,
service
in
of
fact-
Necon. It's like this, supposing.
Lordship.
Now you see, supposing that say some clothes are, say, you can say Boss. You see, Boss company. They make clothes. Okay. Now it's some are manufactured in India. And Boss buys it not from the Indian factory where it is made, but through a middle supplier.
Yes, Lord.
The Boss has got a agreement with the middleman.
Yes, Lord.
Okay.
Yes, Lord.
And
That I
you have
understand.
got a claim for money from the middleman.
But Lordship.
And there is no agreement between the factory owner, that factory person, and that person at Boss. Can you claim your payments directly to Boss when there is no agreement between you and
No,
Boss?
Lordship, in cases of MSME, Lordship, there are special provisions which have been enacted in the MSME Act, Lordship.
Show me that. That's
Lordship,
not so generally. Show me that.
The main provision is section 18, Lordship. Section 18 of the MSME Act, Lordship.
I think we'll take some time, no?
Yes, Lordship.
I'll finish them then. Yes, what to do, Mr. Goswami, for your. What to do?
Tuesday next one.
We have fixed so many matters again. Monday, Tuesday, all. Thursday. We can try on Thursday. Can we finish it on Thursday? Huh?
I will not take that. I have already concluded my.
Can you give me a small gist of your arguments, all of them? Small,
Okay.
short video.
That will be better.
Yes, because you see, this is the first time I have heard a thing that has stretched for so long, and I'm completely lost now.
Something has been dictated.
No, then you lose interest after some time. Because I don't do cases like this. Not my style. So this is the only one. So if you can give me a short gist, so that on that day, we hear it and we finish it off. 15th, 15 might be a problem. Yeah, lovely. We can try on it. If it doesn't happen, then we'll see. If it doesn't happen, then we'll shift. But let's try on it. Yes, Mr. Pegu, anything? Yeah, right. This is a matter on it. This is a matter on it at 2 p.m. Yes. At 2 p.m. Yes, we can continue.
Yes, Lordship. So just like to read two of the most important paragraphs, Lordship.
Huh?
The two important paragraphs of this judgment, Lordship.
Yes, show me the two.
Paragraph 29
and
30. Lordship.
32.
30, 33,
30.
Lordship. 30. Now,
Yes.
Lordship, in this case also, Lordship, the privity of contract that has not been upheld by the learned division bench, Lordship.
These fellows out of station 29.
Yes, Lord. If I can read paragraph 29 and 30, Lordship. From a plain reading of the provisions of the Act of 2006, it is thus apparent that the Act of 2006 is a special statute enacted by the Parliament with objective of protecting the right of micro, small and medium enterprises. The fact that Section 18 of the Act of 2006 begins with a non-obstante clause is sufficient to indicate that the entire entitlement of micro, small and medium enterprises to recover its lawful dues by taking recourse to the mechanism provided under the Act would have an overriding effect on any other law for the time being in force. Therefore, in the event any MSM enterprise coming within the ambit of the Act of 2006 is wrongfully denied payment for goods delivered or services rendered by it, that in that event, regardless of any other law for the time being in force to the contrary, the enterprise will be entitled to recover its dues by taking recourse to Section 18. Section 18 of the Act of 2006, in our view, not only provides an adequate and efficacious remedy to the MSM enterprise to recover its legitimate dues, but the same also provides an opportunity to fast track the resolution of all such disputes. Then, Lordship, in the present case, as has been noted herein above, the fact that the subcontractor is a micro, small and medium enterprise and has supplied goods and or rendered services which was availed by the appellant, number one, as a buyer within the meaning of the Act.
You see, if you want to apply Section 18,
yes, Lord,
then you have got to go to the Felicitation Council.
No, that is why we are here, Lordship.
Right?
Because we are rejected at the Felicitation Council, Lord.
Rejected?
Yes, Lordship, because please have a look at page 102, Lordship.
So when there is a rejection by the council, where do you go?
No, it has not been rejected, Lordship. In such, our case was not admitted because they were asking for bills in case enterprises filing application for UM unit. The date of invoice in dispute should be earlier than 1722. Our bills are later than 1722, Lordship, not earlier. That is why we have come before this on the High Court, Lord. And in fact, Lordship, in this, the division bench has allowed the recovery of dues from appellant number one.
What was the case here before the division bench?
The case,
Para 2 of this judgment, it categorically states, my lord, if I may.
Yes.
My lord, page number 3, para 2, my lord, is 8 line from the top.
Yes.
According.
According to the petitioner.
Since the subcontract was entered into with the principal contractor with due consent and approval of the National Highway and Infrastructure Development Corporation, hence in view of the provisions contained in clause 3.2 of the contract agreement, the subcontractor has stepped into the shoes of the principal contract. The case of the writ petitioner before the learned single judge was that there is no dispute about the fact that the subcontractor has duly executed the work. In such circumstances, payment due to the writ petitioner cannot be withheld by NHI DCL merely because the principal contractor defaulting in completing the work. My lord, over here, the principal contractor was from Spain.
From Spain.
Spain.
Ah.
So the project was allocated to him. During the ongoing work, he executed the subcontractor, and the subcontractor, my lord, came into a contract of privity because the company who had awarded the contract accepted to the subcontract being given. And when the principal contractor left prior to completion of the work, the subcontractor came into the shoes of the principal contractor and completed the project, directly coming into a contractual obligation and a relation with the owner of the project matter. Our case is different from this matter. Because they are an MSME does not mean the law will be different for them. So my lord, the privity of contract, the doctrine has been well established, my lord, long ago in 1909 by the Privy Council, my lord, in Dunlop and Company also. And it has stood water since then. And my lord, SR Shipping is a landmark judgment on the privity of contract, which we have placed. So my lord, over here, the factual scenario which gives rise to this particular judgment is different from the factual scenario where we
And
start.
out here, the subcontract was entered into with due consent and approval.
My lord,
And what about you with you?
there is no consent, there is no approval, my lord.
Lordship,
He is not my subcontractor.
Lordship,
But then you paying,
they were
you
the
paying the
approving-
payment on the request made by Nexon.
My lord.
You have
My-
accepted.
My lord, we accepted, not just to him, to 10 or 15 others. Now the reason is, my lord, that is for the ease working of the contract. That issue has been squarely covered by SR Shipping. In para 2720, it has been very clearly covered over. My lord, the issue that we deal with now over here is that I did not pay him something out of the contract price. When I was paying them, I was deducting it from the account of Nikon. My lord, Nikon was providing work to us. As the work was progressing, RA bills were coming, running account bills, my lord. And after due.
And what is the due payment to you or with regard to what?
1.76 lakhs something.
For what?
Lordship.
For what work?
For various works, Lordship.
My
There are
lord,
number of
But
substations.
who will approve that? Who will approve that work?
That has to be approved by Power Grid Lordship. Nikon and Power Grid Lordship. In fact, Lordship, if we see the minutes of the meetings that are given here, Lordship, the equipments that has to be tested by Power Grid, that has to be approved by Power Grid, and after the approval only payment is due. And they are saying that they have debited the account of Nikon.
My lord.
But if we look at their objection, Lordship, that in the reply that they had filed, they had not said so. They are saying that we are paying to Nikon as well as us.
No, my
So
lord.
if that is the case, Lordship, isn't it the misdeclaration of public fund? And Lordship, in their contract, Lordship, there is no question of giving some subcontracts or anything like that. Still, they were present in the meeting.
I think there's no time.
Lordship.
My lord. My lord, over here, the only litmus test to be applied is that are they coming under the defect liability period? When we give a tender or a contract, my lord, these are equipments which were supplied in the construction and functioning of a substation. Now there is a defect liability period to it, my lord. That defect liability period will only be binding upon Nikon and not them.
Lordship, the question of the defect liability period does not arise here. The equipments have been accepted by them.
No, that's not different. Anyway, I think we'll fix another date. When can you come? We'll fix another date.
My lord, 30th of May.
Not 30th of May. 30th of May is not possible. Lordship.
Why?
But I have a hearing. The
Where?
cat Lordship.
Huh?
Cat Lordship. Central.
Yeah, he ain't got it.
Yes, Lord.
You give a date, you both of you.
My lord,
No time today, otherwise.
we'll inform the Christian.
Okay, right. And due to paucity of time, the matter is adjourned till dash, huh? Mr.
N. Khera.
N. Kera appears for the respondent number 1 and 2, while Mr.
Kedas.
Kedas appears for the petition.